What's your name?
Brenda Bingham's her name.
What's your name, ma'am?
My name is Chris.
But what's your full name so I can look up the case?
It's Brenda Bingham. It's her. I'm with her. I'm her son.
Oh, all right. Well, Miss Bingham, I just did a default because I didn't realize you were here. Yeah. We'll come back to you in a minute. All right. Mr. Duquette, let's take up your matter. I didn't realize that you were in here. Nobody told me. And I called the case and you weren't here. I didn't call the hall like I usually do, so shame on me. And nobody told me you were in the waiting room. So we're gonna have to figure out what we're gonna do. But let's take up Capital One versus Cody Fry. Michelle, would you call Mr. Evers and see if we can get him back here for Consumers Credit Union versus Brenda Bingham? All right, we did our criminal arraignment on Mr. Hostetler and we did a default on, or we settled Miss Inman. Shayna, you can come get the criminal case. Michelle, I didn't realize that Brenda Bingham was here. Apparently she was put in the waiting room and nobody told me and I didn't think to call the hall. She's been here. I entered a default against her as though she were not, because I didn't know she was here. So would you see if you can reach Mr. Evers from Velo Law, see if he can rejoin us to address that case. In the meantime, we're going to take up Capital One versus Cody Fry. Mr. Fry, can you hear me? You got to unmute your mic.
Yes, I can hear you.
Well, I didn't know she was in there and I didn't call out there. See if we can get a hold of the attorney, Mr. Evers,
Okay.
to come back because she is here. It doesn't do any good if you put him in there and I don't know it, but it was on me because I didn't check. Mr. Fry, can you hear me now?
Yes, sir.
This is file number 252282GC. It's entitled Capital One versus Cody Fry. The claim is for $8,007 plus costs, which would bring the matter to a total of $8,163.70. This lawsuit was filed on the defendant. He filed an answer, which wasn't really a very good answer, but he filed a letter saying, I'm willing to pay $50 a month until it is paid off. That was filed in December. $50 a month to pay off a debt of this size would take about 15 years to pay it off. I don't think the plaintiff is willing to wait that long. $13 years, 6 months. Anyway, Mr. Fry, what is set for today is called a motion for summary disposition. They filed that motion and I filed a brief which explains it, but lay people don't normally understand summary disposition. Any lawyers don't understand it. But there's a Michigan Court Rule 2.116. Under C9 and C10 of that rule, they argue that you haven't stated any defense. There is no material issue of fact. You, in your response, acknowledge the debt. You offered to pay $50 a month, but they're not going to wait 13 years without even not counting interest to get this paid off. So they filed this motion. Mr. Duquette, you wish to speak to your motion further?
I have nothing to add to the brief, Your Honor. I will just note that there was no response filed and defendant hasn't met the burden here to establish that there is any issue of fact.
Mr. Fry, could you pay something more than $50 a month?
Yes, I could. I have saved $4,000 to go towards this. And I could pay $4,000
start.
right now. And pay the rest in like $100 a week payment.
All right, well, I'm sure that would be adequate. Let me put you in what's called a breakout room and you can talk privately with Mr. Duquette. And when the button comes up that says join, push it, and then you can speak privately with Mr. Duquette in a breakout room.
Okay.
Ms. Bingaman, we're seeing if we can get the lawyer back. You got sued. They filed a proof of service and you never filed an answer. So they asked me to enter a default. And I set the matter for a hearing because I had a question about whether there was a proof of service. They indicated there was a proof of service, and I did enter the default judgment. When you get sued, you have 21 days to file an answer, and you never filed any response. So they asked me for a default judgment, and I entered one today because they acknowledged that you had a proof of service.
He is be logging back.
All right, so the attorney will be back here in just a moment.
And I still don't have that proof of service in my inbox.
Well, he said he was going to email it. Now we have a. As you said, Oscar Canseco Pedroza.
Yeah. Yeah, it's me.
We have an interpreter joining us here shortly to
Okay.
help with your case.
Okay.
And we call this part hurry up and wait. We do a lot of it. All right, Mr. Evers is back.
Couldn't get on the device.
One.
No,
Mr. Cox's office here yet.
no, Judge, I do not have Mr. Cox's office here yet. And Miss Wade does need to see the video prior to speaking with you, just unless you don't want her to, that's fine. But I have the rest of the 9 o'clocks in the breakout room ready to watch the video. So that's what I'm going to do now.
Okay,
All righty,
thanks.
no problem.
Well, I think I'm gonna get off the bench here for 5 minutes until we have people here, okay? So unless I have something ready right now. Most of these have to do with Mr. Cox's office, though.
He is here, or somebody representing his firm is here, but I believe the defendants are watching the video, Your Honor.
All right. So you need to contract forfeitures. You can serve them anything. If you pay for second name, the defendant is considered served. If they can't get a money judgment against the defendant, it's the defendant's personally served or shows up. But so I can be able to say they paid for a second name. They went out 3 times and that's the man who's required. And they can't serve when they panic at the door. They wake me up on the court. They don't have a possession. You got 10 days in the plan. It's upset to me. If they Sir, your name?
My name is Joseph. I'm with Sally.
All right, so you said you have a hearing problem, right? Or you
Yes.
couldn't. All right, so the defendant was not properly served. This is a land contract forfeiture case. Defendant has to be properly served with the summons and complaint, or there has to be an order that a judge signs for alternate service where there's many attempts, and the judge signs an order saying you can serve by certified mail, first-class mail, and posting or tacking, in which case that would be good enough. But I never signed an order. I was never presented an order. So I'm going to have to adjourn this, and then we're going to have to send the process server out again to get the defendant. You might want to hire a lawyer. This is a little bit more complicated. This is land contract forfeiture. I would suggest you get a lawyer. You don't have to, but you should, okay? This is not just throwing somebody out. You do what you want. You have the legal right to represent yourself, but that's how I'm going to proceed here. We're going to adjourn this. Why don't you give me a new date there, Linda? Or
For just 1 week or 2 weeks, Your Honor?
we got to have him reserved. Let's make it 2 weeks.
Okay, how about, so it'll be April 13th at 8:30?
Perfect. April 13th at 8:30, but I want you to listen, sir. You should get a lawyer. I'm not trying to give lawyers business, but you know, there might have to be a motion for listen. There might have to be a motion for alternate service if they can't find the defendant. So you do what you want. I'd suggest you get a lawyer. You have to have you should get a lawyer. That's all I'm going to say, but you do what you want. Okay. Thank you. Bye. Owner's Management versus Justice Wade, 2601102.
Morning, Your Honor. Attorney David Lechner, P number 67994 on behalf of Owners Management.
Is Justice Wade? I thought she was out there.
She was here. I spoke with her in a breakout room, Your Honor.
Do you see Justice Wade out there, Linda?
Yes, I'm here.
She's in breakout room 20, seeing the video.
Oh, I see. All right. Okay, let's see.
I can hear you. Can you hear me?
Well, I need you to finish watching the video, okay? And then you come back
Okay.
in here.
Yeah, Miss Bordine, please join breakout room. Thank you.
Okay.
Is Park Place here yet? Where's Mr. Cox's office?
I'm bringing him in right now, Your Honor.
All right, Mr. Cox's office is here.
Yes, Mr. Brown.
Okay. Park Place Apartments versus Alays Taylor, 2601131. Good morning, Ms. Taylor. Your name, please?
Alize Taylor.
Good morning to you. Mr. Brown, your appearance?
Good morning, Your Honor. Jeremy Brown on behalf of Plaintiff.
Ma'am, did you listen to and understand the rights on the video?
Yes.
You wish to apply for funding or speak to a lawyer?
No.
All right, so that's again the first thing I asked. Could go through all of this. I want to show you. I could get through all this, but you know, if they watch the video, they can told this. Okay, so now, Mr. Brown, can you tell me just the total amount that is owed?
Sure. $1,399.17.
You agree that you owe that amount, ma'am?
I paid all of it except for that extra yesterday. Like it's all paid off. I wasn't sure because I hadn't gone to court yet, but all of rent is paid. So I haven't paid the court rent, but I've court stuff, but I have paid rent yesterday.
How much did you pay them yesterday?
Yes.
How much did you pay them yesterday?
All of it. Yesterday I paid 500 and the day before that I paid another 500. So not 500. It was like all of it is paid. Like
Wait a minute, listen,
12
please, slow down for me.
Sorry.
I just want to know, can you tell me how much you paid on Saturday, how much you paid on Sunday, each day? I need to know how much you, what? Go ahead.
Saturday I paid 500 and yesterday I paid about 700, I'm pretty sure.
That word about doesn't work with math. Mr. Brown, do you have a record of that?
Not yet. I mean,
Why don't you call the manager and find out? Get him to log in or else I'm just gonna adjourn this a week.
Yeah, I think she admits even though if she paid the 1,200, she hasn't paid the court cost basically. So
good enough. Adjourn it to April 6th at what time, Jennifer or Linda?
It'll be 10 o'clock. I'm sorry. April
Ma'am, I want
6th,
you to
10 o'clock.
understand, 10 o'clock in the morning. Make sure that you paid the whole balance and then they will dismiss it. So you have to know
Okay.
exactly how much you paid. He thinks you owe $13.99.17 less whatever you paid in the last 2 days. So I'll adjourn it until next Monday. It would be nice if you didn't have a judgment on your record and you can take care of this and then they'll just go ahead and dismiss it, okay?
Okay, if I pay everything by Friday, do I still have to come or do I come on Friday?
Just want you to make sure that you have a dismissal in order in hand before you don't show up. So show up unless you have an order of dismissal that I've signed and has been sent to you and received by you, okay?
Okay, thank you.
Have a good day.
You too. Bye-bye.
Gibraltar Point versus Joseph Kowalski, 2601100. Mr. Kowalski, your name?
Joseph Kowalski Jr.
Mr. Brown, your name?
Jeremy Brown on behalf of Plaintiff.
Sir, did you listen to and understand the rights on the video?
Yes, Your Honor.
Do you wish to apply for funding or speak to a lawyer?
No.
How much is owed on this one, Mr. Brown?
$1,368.34.
You agree that you owe that amount?
No, sir.
How much do you owe now?
$630.
When did you pay the other?
I paid 548 something this morning. Then last week or the week before I paid another 600 or something like that. But it shows on my account on Rent Cafe for Gibraltar
How much do
Point.
you owe
It has
that?
$630, which I will pay tomorrow.
Mr. Brown, is it me or can the office not text you or email you or show up when they've got these payments? I don't want to have to keep adjourning these if we can avoid it. I'm gonna adjourn this one to April
If you
6th.
paid this morning, I don't think they would have that
Okay, April 6th at what time? Linda?
10
Is this
o'clock, Your Honor.
Is this at 10:02? So
Yeah.
you need to pay everything by then, sir.
Okay,
Okay.
I'm sorry to interrupt. So when I pay the rest tomorrow, am I gonna get something in the mail or is it just gonna be canceled tomorrow?
I would still show up unless you have a dismissal order that I've signed in your hand by Saturday.
Okay.
Okay?
All right, I appreciate it.
All right, we want to make sure that we don't make any errors up here or something doesn't cross in the mail. You don't want a judgment entered against you, okay?
Yeah. All right, I appreciate it, Your Honor. Thank you.
Have a good day. Thank you
You
very
too.
much. Epic Property versus. Do I have Brandy Blaz? Jerry Taylor here, 2600936.
No, I don't see either one of those, Your Honor.
This was a termination, Your Honor. They appeared and they said they were going to be turning in the keys. And I talked to my client this morning. They said they still haven't turned the keys. They left a note in the door saying they vacated, but they have not returned the keys. So it's kind
So
of
you need a judgment. So you need a
Yeah.
judgment. I'll give you a judgment by default. So we'll give you a writ date of April the 9th.
Okay.
Will you please give me that judgment this morning, though?
Well, I'll get to it right after.
Inundated with these landlord tenants on these days, so I want to make sure I get to it today, okay? Thank you.
Understood.
Epic Property versus Jillian Carroll and Ryan Carroll, 2601087.
I have had neither defendant show up, Your Honor.
You paid for a second mailing. This is for non-payment of rent. You can go ahead and give me your breakdown, and I'll give you a default.
Thank you, Your Honor. The rent to retain possession, $1,121. Cost of $223.56 for a total of $1,344.56.
Are there any late fees?
Checking right now, Your Honor. The late fees, I know you kept them at 75. There is two $50 late fees, Your Honor.
So your principal sum is only 1,021, true?
Correct. What?
Oh.
Hold on, Your Honor. Wait a minute, Your Honor. I'm looking at this ledger. They've already added. No, wait. So they made a payment of $1,304 on the 26th. Take it to a zero balance. So the numbers that I'm giving are April 1st numbers. So then this should just be dismissed, Your Honor.
Okay.
Yeah,
Makes
because
it
this
easy.
is it's $1,400 the amount, and that is all from April 1st. So yeah, so they made the payment and zero the balance out on the
Good
26th.
enough. Case dismissed. Motion of the plaintiff, Epic Property versus Kenaz, Lawson, and Lenina Shields, 2601088. Are either of them here?
I've had neither one check in, Your Honor.
All right, well, I gave him 15 minutes. It was scheduled for 9. You can go ahead and take a default.
I'm checking this again to make sure it's not the same situation. So no, so this one is, there is a balance. So yes, at the rent to retain possession, $1,198.14, costs of $223.56 for a total of $1,421.70. And similar to the last one, there are two $50 late fees.
So it's 1,098.14 plus 100 plus 223.56 for 1421.70. True?
Correct, Your Honor. Yes.
I'll just ask you to break those down if you can for me. So writ will issue, default judgment will enter 1421.70. Writ date will be on the 9th of April. Epic Property versus Lawrence Singer, 2601090. Is Ms. Singer here? Good morning, ma'am. Your name?
Lauren Singer.
All right, Mr. Brown. Your appearance?
Jeremy Brown on behalf of plaintiff, sorry.
Ma'am, did you listen to and understand the rights on the video?
I did, and I
Do you
do.
do you wish to speak to a lawyer or apply for funding?
No, thank you.
All right, so you waive those rights, correct?
Correct.
All right, Mr. Brown, just give me the total amount owed.
Total amount owed $2,100.17, and that's through the month of March. So obviously April's will be added on.
Do you agree that you owe that amount, ma'am?
No, not particularly. The amount I have is about $300 less, unless
Okay,
those are the
about,
court fees that I'm not aware of.
We can't have about. Math's good. Math's perfect. Math's easy. We know how much, there's no abouts. So are you not including the
1866.
court costs in this?
Me or Jeremy?
Give me a break good down, please.
Sure. I'm checking the
Rent to
late
retain.
fee. Rent to retain. Then this includes $200 in late fees. So $1,816.
So it's
$100 in late
1,716 plus 100 in late, $250 late fees. How much in costs and attorney fees?
It was $1,816, $100 in late fees for 1916, and then court costs $184.17. And so that's
All
a
right.
total of $2,117.
Say that again.
1816. rent to retain.
2,117, is that the total?
Correct. $2,100.17. Correct, Your Honor.
So how much do you calculate that you owe, Ms. Singer?
Well, I had 1866 even, but that was obviously without the court fees.
All right, so do you agree now based on that, what he just said, that you owe the $2,100.17?
I do.
You gonna be able to pay that?
Yeah, I'm gonna pay it tomorrow.
You're gonna have all of it tomorrow?
Yep. I mean, unless you'd like to extend it, I'd be more than happy to have extra time, but yeah.
So just so you understand, so if we, so they'll,
Here's
what
what-
they'll do is adjourn it till, it'll be in April, so they add April's on at the next hearing. So just
Okay.
be aware that the next hearing will be April, a week from today, basically. So then they'll add April's rent automatically on there. So just understand that April's rent will be coming up due pretty much like normal. You'll have 10 days from the next hearing to pay that April portion of it.
I'm gonna make the writ date on this one, the 10th, counsel, okay?
Oh, you
So
want to go ahead and enter? Okay, that works. Yeah, that's
you can
fine.
prepare a judgment to that effect. Now, keep in mind, though, that this is not going to include April's rent. So
Right.
you're gonna have to pay that. I don't know what your lease says to avoid any other late fees. You don't want to get into that. So make sure you pay that. How much is the monthly rental rate again?
Well, starting April 1st, it's 1845.
Okay. So you'll have to pay that to avoid late fees. When do the late fees kick in with this complex, Mr. Brown?
The second that you're late.
The
Yeah, it looks
second?
like on the
No,
second
like
of the
the
month.
second. Yeah, the
And
second.
those late fees are 50 per month?
Yes.
Correct.
Okay. All right, so make sure you take care of that then, okay? You gonna be able to pay all of this?
I will.
All right, I wish you well. Send me
Thank
your
you.
judgment on that one, Mr. Brown. Good luck to you, ma'am. Thank
Thank you. I
you.
appreciate it. Have a good day.
You too.
Thank you.
Do you have any more?
I don't think so. We knocked those out. Let's see.
Thought I had.
Yes,
Okay, I think
there's-
you're all
there-
set.
Wait a minute,
Oh,
Your
no, you
Honor,
got
there's
SRM Group.
yeah.
SRM Group versus Siobhan Brown.
Yeah.
2601152.
Yes, I'm here, Your Honor.
Okay, ma'am, can you tell me your name, please?
Siobhan Brown.
Did you listen to and understand the rights on the video?
I did.
You wish to speak to a lawyer or apply for funding?
No.
So you waive the rights?
Yes.
All right. Mr. Brown, your name,
Jeremy Brown, on behalf of plaintiff.
total amount due as of right now, just the total.
$1,348.34.
Do you agree that you owe that amount, ma'am?
Yes, I agree.
You gonna be able to pay that?
Yes, I'll be able to pay it in a couple of weeks, but Your Honor, I need to state something. My landlord and I had already concluded that I have a move out date on April 11th. And I also
Wait a minute, slow down.
okay. Okay,
Did
let
you,
me start
do we
over.
have, hang on one second. Do we
Sure.
have this in, wait a minute. Are you in the middle of a lease or is this the month-to-month lease?
It's a lease. Yes, but it's up totally April 30th. But I had already told the landlord that I'm moving out on April 11th.
Well,
And
you still are gonna be, according to what you just told me, responsible for April's rent, right?
yes, I understand that. Yes, but they filed the eviction before I even they filed the eviction right after I put in my 30-day notice. So I was gonna ask for
So you gave
conditional
them
dismissal.
notice you were moving out on April 30th or April 11th?
No, I like 2 or 3 weeks ago, I notified them that I was moving out on April 11th. And this was way before they even filed the judgment.
They don't have a judgment yet. They filed their complaint, you mean, right? So I've been giving them a judgment. But the point is, if you move out, you're gonna be stuck with April's rent.
Yes, I am aware of that.
When are you gonna pay this?
I'm gonna pay what's today? Today is the 30th.
No, it's the 30th.
Yes, the 30th. So I'm gonna pay them in a couple of weeks. I'll have the money in a couple of weeks.
What do you want to do, Mr. Brown?
I mean, I guess just adjourn it. I guess just set it over to the next hearing, and then that'll be the total balance she owes, and then she's going to be leaving anyway. So I guess just set it over for one more.
Well, you didn't include the April rent, though.
Correct.
Right?
No, I did not include the April rent. No.
How much is the rent there, ma'am?
$982.
So you're gonna owe that too. You understand that, right?
Yes, I understand that.
So you want me to adjourn it for 1 week, Mr. Brown?
I do. Yes.
Is this at 10 o'clock, Linda? We'll make it the 6th at 10 a.m.
Yes, Your Honor.
Okay, so we'll make it the 6th at 10 a.m. All right? Good luck,
Okay.
man. Good luck to
Thank you.
you. Thank
Thank
you.
you.
Thank you, Your Honor.
Thanks. That's it for you. Thank you. Owner's management versus Justice Wade. Now, these terminations would cause happiness. Some of these cases, let me see what this one, yeah. See, you'll see them complain to recover possession and everything. And it's not because there's an active like.
Pardon me, to the lady on the
So-
Samsung, I need you to please
This is
join the breakout room.
2601102 LT. I'm sorry. Mr. Leckner,
okay.
your name?
Good morning, Your Honor. David Leckner for Owners Management.
So they won't. This is a different form of termination. Ma'am, your name?
Justice Wade.
And they're saying she has to get out because she violated rules. You know. Extra. Didn't see any of that information and not clicking through the property. All right, ma'am, did you listen to and understand the rights on the video?
I did.
And do you understand everything that was said there?
I did.
You wish to speak to a lawyer or apply for funding?
Yes, I would like to speak to a lawyer.
What are the allegations here, Mr. Leckner?
Your Honor, the allegations are numerous noise complaints, leaving garbage or other items in the common areas, not refusing, excuse me. Failure to maintain common areas in a safe condition, arranging for collection and removal of trash, failing to arrange for collection and removal of trash or garbage, like I said, noise complaints. There are a number of different.
All right, let's
other
adjourn this to April 6th, and that will give you an opportunity to talk to a lawyer, Ms. Wade. Lakeshore will talk to you. They will chat with you in the breakout room, and they'll tell you where to call. You should call there today and follow up if you don't hear in the next day or two, so you can talk to a lawyer before you come here, okay?
Okay.
April 6th at what time?
9:30, Your Honor.
at 9:30 will be your court date. So that's 1 week. So make sure you follow up with that, okay?
Okay,
Best of luck to you, ma'am.
thank you.
Owners
Thank you, Your Honor.
Management versus Jill Bordine, 2601161. Good morning, Ms. Bordine. Your name?
Good morning, Jill Bordine.
Mr. Lechner, your appearance.
Good morning, Your Honor. David Lechner on behalf of Owners Management.
All right, so no, this is supposed to leave. Payment. Did you listen to and understand the rights, ma'am?
Yes, I did.
Would you wish to speak to an attorney or apply for funding?
I plan to apply for funding.
All right, now, here's what I'm gonna have you do. Thank you. So that buys you a 2-week adjournment. We're gonna adjourn this to April the 13th. At what time, Linda?
9:30, Your Honor.
At 9:30. Now, I want you to understand that you have to provide us with proof that you've made an application for funding within 5 days. Okay? So you
Yes.
have to bring that proof up here. And if you
Okay.
do that and you haven't heard, then I will, in essence, be able to give you another adjournment. But in the meantime, you have to provide us with proof that you made that application for funding. I'm adjourning it to April the 13th at 9:30 in the morning, okay?
April 13th. Yes, thank you so much.
All right, so make sure you bring that up here. I wish you well. Good luck. Hope you can get some money. Mr. Luckett, that's good for you, right?
It is, Your Honor. Yep.
Have a great day.
Thank you.
Thank you
You as
very
well.
much.
Thank you so much, Your Honor.
Good luck. Bridgewood Apartments versus Tila Davis, 2600694.
Good morning, Your
Good
Honor.
morning.
Jim McCardle on behalf of the plaintiff.
Good morning, Mr. McCardle. Is Tila Davis?
Your Honor,
here?
I have not had her check in.
So
Tila Davis.
she was here March 2nd. She said she intended to apply for funding. I gave her the 2-week adjournment. We came back. I adjourned it again to the 23rd and then again till today. That was on the 16th that I adjourned it to the 23rd. So counsel, you can go ahead and take a default.
Thank you, Judge. Do you want the figures on the record?
Please, beginning with the principal balance.
Rent to retain is $1,886.11. The costs are $191.11 for a total of
I need
$2,077.
the late fees. How much are your late fees?
That's included in the cost, Your Honor.
I know, but I cap them at 75 and I want to make per month, and I want to make sure that these do not exceed. Sometimes that happens. That's why I require that. So I'm going to ask you if
I've got 150 in late fees of that.
is that for 2 months?
Yes, Your Honor.
So essentially we have 150 in late fees and 1736.11 in past due rent plus the 191.11. True?
Correct, Your Honor.
And so what does that come out to? 1886, 2086.
$2,077.22.
It went out. I couldn't hear you.
$2,077.22.
Judgment will enter. Writ date will be on April the 9th. I just asked that you make sure you get that to me this morning, okay?
I will do so, Judge. Thank you.
Bridgewood versus Brianna Avila and Derek King Jr., 2601093.
Again, Jim McCardle on behalf of the plaintiff, Your Honor. I doubt the court has seen it yet, but I submitted a dismissal about a half hour ago.
All right, good enough. Case dismissed, motion of the plaintiff. That's easy for us. Do you have more?
Yes, Your Honor. I've got 2 other clients, 3 other cases.
Okay, yeah. Who you have? Granite Valley?
Yes, Your Honor.
You do. Granite Valley versus Ronald Bodges, 2600973.
Again, Jim McCardle on behalf of the plaintiff.
So this one, and it was kind of strange, you guys started a termination of tenancy action, and then you guys started this action, and the termination of tenancy action was based on the fact that he was charged, I believe, felonious assault, and that he'd assaulted somebody on the premises. You guys did not join that. I did not feel comfortable proceeding with that case. So in other words, I think usually people are, if they're gonna do both, they're gonna include them in both. But the point is that I was not prepared to enter a judgment or require him to go to a hearing when he has the Fifth Amendment right to remain silent on the assault case. And it would just have been improper. So you guys started this action. He was here last week. What time was this scheduled? Linda, 9:30?
You mean today?
Yeah.
Yeah, 9:30.
I'm just surprised he isn't here. I'm gonna give him, I do have, I always try to give somebody 15 minutes. And I'm gonna pass that one for 15 minutes. Is Pamela Borden here? She is. So I can take this one. This is Granite Valley versus Pamela Borden, 2600975. Ms. Borden, good morning. Your name, ma'am? Ms. Borden, can you hear me? Ms. Borden, can you hear me, ma'am? Do we have her phone number by chance, or do you, Mr. McCardle?
I don't, Your Honor.
Do we, Linda or Jennifer?
I doubt we have it. I can take a look, but we don't usually have the defendant's phone numbers.
Yeah, I
But
get it.
I'll look.
Can you do me a favor? Can you
Sure.
chat with her? Jennifer.
And
I'm checking the
Rent to
late
retain.
fee. Rent to retain. Then this includes $200 in late fees. So $1,816.
So it's
$100 in late
1,716 plus 100 in late, $250 late fees. How much in costs and attorney fees?
It was 1,816, $100 in late fees for 1916, and then court costs 184.17. And so that's
All
a
right.
total of 2,117.
Say that again.
1816. rent to retain,
2,117, is that the total?
$2,100.17, correct, Your Honor.
So how much do you calculate that you owe Ms. Singer?
Well, I had 1866 even, but that was obviously without the court fees.
All right, so do you agree now based on that, what he just said, that you owe the $2,100.17?
I do.
You gonna be able to pay that?
Yeah, I'm gonna pay it tomorrow.
You're gonna have all of it tomorrow?
Yep. I mean, unless you'd like to extend it, I'd be more than happy to have extra time, but yeah.
So just so you understand, so if we, so they'll, what they'll do is adjourn it till, it'll be in April, so they add April's on at the next hearing. So just
Okay.
be aware that the next hearing will be April, a week from today, basically. So then they'll add April's rent automatically on there. So just understand that April's rent will be coming up due pretty much like normal. You'll have 10 days from the next hearing to pay that April portion of it.
I'm gonna make the writ date on this one the 10th, counsel, okay?
Oh, you
So
want to go ahead and enter? Okay, that works. Yeah, that's
you can
fine.
prepare a judgment to that effect. Now, keep in mind, though, that this is not going to include April's rent. So
Right.
you're gonna have to pay that. I don't know what your lease says, to avoid any other late fees. You don't want to get into that. So make sure you pay that. How much is the monthly rental rate again?
Well, starting April 1st, it's 1845.
Okay. So you'll have to pay that to avoid late fees. When do the late fees kick in with this complex, Mr. Brown?
The second that you're late.
The
Yeah, it looks
second?
like on the the
No,
second
like
of the
the
month.
second. Yeah, the
And
second.
those late fees are 50 per month?
Yes.
Correct.
Okay. All right, so make sure you take care of that then, okay? You're gonna be able to pay all of this?
I will.
All right, I wish you well. Send me
Thank
your
you.
judgment on that one, Mr. Brown. Good luck to you, ma'am. Thank
Thank you.
you.
I appreciate it. Have a good day.
You too.
Thank you.
Do you have any more?
I don't think so. We knocked those out. Let's see.
Thought I had.
Yes,
Okay, I think
there's-
you're all
there-
set.
Wait a minute, Your
Oh, no, you
Honor,
got
there's
SRM Group.
yeah.
SRM Group versus Siobhan Brown.
Yeah.
2601152.
Yes, I'm here, Your Honor.
Okay, ma'am, can you tell me your name, please?
Siobhan Brown.
Did you listen to and understand the rights on the video?
I did.
You wish to speak to a lawyer or apply for funding?
No.
So you waive the rights?
Yes.
All right. Mr. Brown, your name,
Jeremy Brown, behalf of plaintiff.
total amount due as of right now, just the total.
1,348.34.
Do you agree that you owe that amount, ma'am?
Yes, I agree.
You gonna be able to pay that?
Yes, I'll be able to pay it in a couple of weeks, but Your Honor, I need to state something. My landlord and I had already concluded that I have a move out date on April 11th. And I also
Wait a minute, slow down.
okay. Okay,
Did
let
you,
me start
do we
over.
have, hang on one second. Do we
Sure.
have this in, wait a minute. Are you in the middle of a lease or is this the month-to-month lease?
It's a lease. Yes, but it's up totally April 30th. But I had already told the landlord that I'm moving out on April 11th.
Well,
And
you still are gonna be, according to what you just told me, responsible for April's rent, right?
yes, I understand that. Yes, but they filed the eviction before I even they filed the eviction right after I put in my 30-day notice. So I was gonna ask for
So you gave
additional
them
dismissal.
notice you were moving out on April 30th or April 11th?
No, I like 2 or 3 weeks ago, I notified them that I was moving out on April 11th. And this was way before they even filed the judgment.
They don't have a judgment yet. They filed their complaint, you mean, right? So I've been giving them a judgment. But the point is, if you move out, you're gonna be stuck with April's rent.
Yes, I am aware of that.
When are you gonna pay this?
I'm gonna pay what's today? Today is the 30th.
No, it's the 30th.
Yes, the 30th. So I'm gonna pay them in a couple of weeks. I'll have the money in a couple of weeks.
What do you want to do, Mr. Brown?
I mean, I guess just adjourn it. I guess just set it over to the next hearing, and then that'll be the total balance she owes, and then she's gonna be leaving anyway. So I guess just set it over for one more.
Well, you didn't include the April rent though.
Correct. No,
Right?
I did not include April rent.
How much is the rent there, ma'am?
$982.
So you're gonna owe that too. You understand that, right?
Yes, I understand that.
So you want me to adjourn it for 1 week, Mr. Brown?
I do. Yes.
Is this at 10 o'clock, Linda? We'll make it the 6th at 10 a.m.
Yes, Your Honor.
Okay, so we'll make it the 6th at 10 a.m. All right? Good luck,
Okay.
ma'am. Good luck
Thank
to
you.
you. Thank
Thank
you.
you.
Thank you, Your Honor.
Thanks. That's it for you. Thank you. Owner's management versus Justice Wade. Now, these terminations for cause happen in some of these cases. Let me see what this one, yeah. See, you'll see them complain to recover possession and everything. And it's not because there's an active like.
Pardon me, to the lady on the
So-
Samsung, I need you to please
This is
join the breakout room.
2601102 LT. I'm sorry. Mr. Leckner,
okay.
your name?
Good morning, Your Honor. David Leckner for Owner's Management.
So name one. This is a different one. Termination. Ma'am, your name?
Justice Wade.
And understand she has to get out because she violated rules. Extra. Consumer without permission and not clicking through the property. All right, ma'am, did you listen to and understand the rights on the video?
I did.
And do you understand everything that was said there?
I did.
You wish to speak to a lawyer or apply for funding?
Yes, I would like to speak to a lawyer.
What are the allegations here, Mr. Leckner?
Your Honor, the allegations are numerous noise complaints, leaving garbage or other items in the common areas, not refusing, excuse me. Failure to maintain common areas in a safe condition, arranging for collection or removal of trash, failing to arrange for collection or removal of trash or garbage, like I said, noise complaints. There are a number of different.
All right, let's
other
adjourn this to April 6th, and that will give you an opportunity to talk to a lawyer, Ms. Wade. Lakeshore will talk to you. They will chat with you in the breakout room, and they'll tell you where to call. You should call there today and follow up if you don't hear in the next day or two, so you can talk to a lawyer before you come here, okay?
Okay.
April 6th, at what time?
9:30, Your Honor.
At 9:30 will be your court date. So that's 1 week. So make sure you follow up with that, okay?
Okay.
Best of luck to you, ma'am.
Thank you.
Owner's
Thank you, Your Honor.
Management versus Jill Bordine, 2601161. Good morning, Ms. Bordine. Your name?
Good morning, Jill Bordine.
Mr. Leckner, your appearance.
Good morning, Your Honor. David Leckner on behalf of Owner's Management.
All right, so no, this is supposed to leave. Did you listen to and understand the rights, ma'am?
Yes, I did.
Would you wish to speak to an attorney or apply for funding?
I plan to apply for funding.
All right, now, here's what I'm gonna have you do. Thank you. So that buys you a 2-week adjournment. We're gonna adjourn this to April the 13th. At what time, Linda?
9:30, Your Honor.
At 9:30. Now, I want you to understand that you have to provide us with proof that you've made an application for funding within 5 days. Okay? So you
Yes.
have to bring that proof up here. And if you
Okay.
do that and you haven't heard, then I will, in essence, be able to give you another adjournment. But in the meantime, you have to provide us with proof that you made that application for funding. I'm adjourning it to April the 13th at 9:30 in the morning, okay?
April 13th. Yes, thank you so much.
All right, so make sure you bring that up here. I wish you well. Good luck. Hope you can get some money. Mr. Leckner, that's good for you, right?
It is, Your Honor. Yep.
Have a great day.
Thank you.
Thank you
You as
very
well.
much.
Thank you so much, Your Honor.
Good luck. Bridgewood Apartments versus Tila Davis, 2600694.
Good morning,
Good
Your Honor.
morning.
Jim McCardle on behalf of the plaintiff.
Good morning, Mr. McCardle. Is Tila Davis
Your Honor,
here?
I have not had her check in.
So
Tila Davis.
she was here March 2nd. She said she intended to apply for funding. I gave her the 2-week adjournment. We came back. I adjourned it again to the 23rd and then again till today. That was on the 16th that I adjourned it to the 23rd. So counsel, you can go ahead and take a default.
Thank you, Judge. Do you want the figures on the record?
Please, beginning with the principal balance.
Rent to retain is $1,886.11. The costs are $191.11 for a total of
I need
$2,077.
the late fees. How much are your late fees?
That's included in the cost, Your Honor.
I know, but I cap them at 75 and I want to make per month, and I want to make sure that these do not exceed. Sometimes that happens. That's why I require that. So I'm going to ask you.
I've got 150 in late fees of that.
Is that for 2 months?
Yes, Your Honor.
So essentially we have 150 in late fees and 1736.11 in past due rent plus the 191.11. True?
Correct, Your Honor.
And so what does that come out to? 1886, 2086.
$2,077.22.
It went out. I couldn't hear you.
$2,077.22.
Judgment will enter. Writ date will be on April the 9th. I just asked that you make sure you get that to me this morning, okay?
I will do so, Judge. Thank you.
Bridgewood versus Brianna Avila and Derek King Jr., 2601093.
Again, Jim McCardle on behalf of the plaintiff, Your Honor. I doubt the court has seen it yet, but I submitted a dismissal about a half hour ago.
All right, good enough. Case dismissed, motion of the plaintiff. That's easy for us. Do you have more?
Yes, Your Honor. I've got 2 other clients, 3 other cases.
Okay, yeah. Who you have? Granite Valley?
Yes, Your Honor.
You do. Granite Valley versus Ronald Bodges, 2600973.
Again, Jim McCardle on behalf of the plaintiff.
So this one, and it was kind of strange, you guys started a termination of tenancy action, and then you guys started this action, and the termination of tenancy action was based on the fact that he was charged, I believe, felonious assault, and that he'd assaulted somebody on the premises. You guys did not join that. I did not feel comfortable proceeding with that case. So in other words, I think usually people are, if they're going to do both, they're going to include them in both. But the point is that I was not prepared to enter a judgment or require him to go to a hearing when he has the Fifth Amendment right to remain silent on the assault case. And it would just have been improper. So you guys started this action. He was here last week. What time was this scheduled? 9:30?
You mean today?
Yeah.
Yeah, 9:30.
I'm just surprised he isn't here. I'm going to give him, I do have, I always try to give somebody 15 minutes, and I'm going to pass that one for 15 minutes. Is Pamela Borden here? She is. So I can take this one. This is Granite Valley versus Pamela Borden, 2600975. Ms. Borden, good morning. Your name, ma'am? Ms. Borden, can you hear me? Ms. Borden, can you hear me, ma'am? Do we have her phone number by chance, or do you, Mr. McCardle?
I don't, Your Honor.
Do we, Linda or Jennifer?
I doubt we have it. I can take a look, but we don't usually have the defendant's phone numbers.
And I get
But
it.
I'll look.
Can you do me a favor? Can you chat with her? Chat with her and tell her that I can't hear her to make sure she it looks like her video started.
Yeah, it does.
Either volume is down or there's some other problem with her device. If she cannot correct that, then one of two things are going to have to happen. Trying to think of where that Granite Bell. How far of a drive is that from here? Can somebody tell me, Linda? Do you know?
No, but I could ask somebody here. Hang on.
Why don't you chat with her and make sure she can hear you? And I might just have her come up here. She's either gonna have to fix her device or she's gonna have to appear personally this morning. And I don't want to keep Mr. McCarter waiting too long. So
Judge, I
chat
am
with
trying-
her. I'll go on to another one. I mean, I could see her. She looks like her video started. And we will go
cannot
from
hear.
there. Oh,
She said
Oh.
she cannot hear. Can
Can
you
you hear
hear
me
me,
now?
ma'am?
ma'am, can you hear me now? Oh, she just got done telling me she can't hear. So she must not be able to. Ask her in a chat if she can drive up here right now.
Yeah,
Okay, Your Honor, we're on it.
So I'll go on to another case right now. Do you have another one, Mr. McCarter?
Yes, Your Honor, it's an
Yes.
easy one for the court.
Orleans Place versus Ronald Johnson, 2601092. Your appearance?
Again, Your Honor, Jim McCardle on behalf of the plaintiff, and again, Your Honor, I filed a dismissal about a half hour ago on this case.
Case dismissed, motion to plaintiff. Case dismissed,
Judge.
motion to plaintiff. Just make sure that Ronald Johnson didn't show up so we can at least give him the courtesy of telling him that the case has been dismissed, if you would. I'm gonna just beg your indulgence on this, Mr. McCardle. I'll see what I can do on board and I'll be back with you as soon as I can. And I will recall Bodges momentarily.
Thank you, Your Honor.
Williamsburg versus Salim Shahzad, 2601091. Do I have somebody here for Williamsburg?
Judge, I do believe that is who Mr. Baydoun is. I'm not 100% sure. I'm trying to chat with him. Uh,
I just brought him in.
Yes, good morning. I apologize for not responding to the chat.
You're fine. Your name?
Mohammed Baidoun appearing on behalf of Williamsburg LLC.
Mr. Shahzad, can you hear me, sir?
Good morning, Your Honor.
Tell me your name if you would, please.
Kaleem Shahzad.
All right, so this is a landlord-tenant action. It's just a termination of tenancy. Did you listen to and understand?
Can I make a request?
Wait 1 second. I want to make sure that you listened to and understood the rights.
Okay, Your Honor.
No, listen to my question. Did you listen to the video and understand all the rights on the video?
Yes, Your Honor.
Do you wish to apply? There's nothing to apply for funding about. This is just a termination of tenancy. Do you wish to speak to a lawyer?
I was trying to explain, can I?
Well, I want to know first if you want to talk to a lawyer.
I don't have a lawyer. I don't want to.
And you don't want to?
I don't hire a lawyer yet.
I cannot hear anything.
Okay, keep your voice up. I'm having a hard time understanding. Are you telling me you don't want a lawyer?
I don't have a lawyer. I have to represent through my son.
Well, your son isn't a lawyer. I can't let him represent you.
Okay.
You can understand me, right?
Yeah, that's why I'm trying to make a request. If I have my son can speak on behalf of me.
I can't let him do that. He's not a lawyer. Why can't you tell me?
Okay. I am living in this place for since 2012, and I have paid my rents on time all the time, and couple of times in a whole entire time over 12 years, we only signed 2 times the lease. And at the last lease, they were asking to vacate the place, but I requested them that I am building my home. Please allow me to stay here until the June. So they said, no, you have to evacuate the place. I never been late for my
I know, but Mr. Baidoun, do you want to respond to that?
Yeah, yes, Your Honor. As indicated, we submitted a notice to quit for recovery of possession. This notice to quit was actually sent out in January, but it was, I believe, the 3rd time it was requested to the tenant to vacate the property. The first time being verbally through the property manager. The second time, which was mailed out, which he refused service for. And then the 3rd time, we were finally able to get him served. The landlord has requested this property back all 3 of these times for personal needs. It's requested him because he needs the property back. He's in no way, shape, or form trying to, do anything nefarious towards the landlord, but pursuant to the agreement, he needs the property back for personal reasons. He has a daughter that he would like to put in the property, and it's his property, and he has the right to it, Your Honor.
Oh, Mr. Shahzad, there's not much I can do for you. I can't just make my own rules up here. And they're entitled to the property back by all means that I can tell. It became a month-to-month tenancy when the lease expired at the end of April of 25. And there's not anything I can do. I can't say you. What do you have to say?
I have not received any notice for month to month. All of us asking to just leave. And I requested the property manager, and he was kept on saying back and forth, let me talk to the owner, let me talk to the owner. He was not clear that you have to leave now. He was kept on saying to me, and all of a sudden, I got the letter from the lawyer. When I called him back, he said, well, I didn't know that they're gonna hide the Lord, but
Asking me to do, sir, I can't let you stay in there until June. I can't let that happen. These are not my rules. I don't make my own rules. I don't write statutes. I don't write court rules. I mean, I know what they are and I follow them. I can't do that for you. I'm sorry. I really am.
can I stay until May?
You're asking for a lot. They're entitled to the property by April the 9th.
Sir,
They did, sir, I can't do that. I just can't do that. I'm sorry. But what day did you send out your notice to quit? Your notice to quit was sent out January 21. So you've known that you have to be out now for over 2 months. They told you you had to move out by February 20th. You can talk, sir. You don't have to raise your hand.
I spoke with the property manager. He was saying, let me talk to the landlord. Then he will get back to me. That's how the time got left. If he had told me he have to leave it now, since he was talking to back and forth to the owner because he lives abroad, that's how it took the time. And then they saw that if they cannot get in touch with the landlord, that's how they just make it sure to make me evict this.
I can't do anything for you. You're asking me to disregard laws, and I will not do that. I cannot do anything for you. You have no proof of this. They filed January, what did I tell you? January 12th, the notice to quit. January 21, it said you had to be out by February 20. This is March 30. I can't just extend out of the goodness of my heart. I don't owe this. I can't do that. This is not my money. This is not my property.
I have nowhere to go, sir.
I don't know what to tell you. Mr. Beydoun, do you care to expound upon what you've already said?
I guess the only thing that I would add, Your Honor, is although the notice to quit that was finally served on January 21st, the tenant was made aware of our request since October of 2025. Other than that, I can't really speak to anything else, Your Honor. The landlord has made it very clear that he does need the property back, and he's given him more than enough time to vacate
Has
the
he
property.
been accepting rent?
He stopped accepting rent as of February of 2026. He did not accept rent for March.
Go ahead.
I paid the rent for the March as well.
That payment was denied, Your Honor.
When did you pay the rent for March?
On the 27th, because from the
Hold on. March 27th, you paid the March rent, or February 27th, you paid the March rent?
I paid the February already, then I paid the March rent because from the landlord, it was denied. Then I sent to the property manager.
Well, they accepted rent after they sent out the notice to quit, though.
We stopped
Right?
accepting. We stopped accepting rent in February, Your Honor. We have not accepted.
Day
rent
was the
for March.
February rent paid?
I could double check, Your Honor, but I believe that there was nothing accepted since
Your
February.
Honor, may I add a detail?
No, sir, I cannot let you speak. I'm sorry.
I
I'm
understand.
sorry. I really am.
I have a proof of paid the rent for March.
Wait 1 second. Let me sort this out, okay?
Thank you, sir.
How did you pay the March rent?
Through Zelle.
I'm sorry?
Through Zelle?
Zelle, right, I get it. Did your client accept that payment? Did your client accept the payment in February?
I
Yes.
see. Your Honor, if I may, I could say for certain that payment was not accepted as of March.
Well, did they accept one for February?
I'm not certain, but I do see that there was a payment for February, Your Honor. As of it was paid on February 9th, 2026, not March.
Why shouldn't I dismiss the case? They can't accept a payment after they cannot accept the payment after they've terminated tenancy with a notice to quit. Why should I not dismiss the case?
Your Honor, if you just give me 1 second to reference my notes, I apologize.
Problem. Your client made a mistake by accepting that rent, right?
Your Honor, if
Tough
you
to
could
be
just
a
give me
lawyer sometimes, isn't it, Mr. Baydoun? Tough to be a
yes,
lawyer.
yes, I'm just trying, if you would just give me a second to confirm if the.
I'll
the
give
payment,
you
Your
all the
Honor-
time you need. I can go
Thank-
on to another case. I'm not here to rush.
I appreciate
I'll
Your
pass
Honor.
the-
I don't
I'll
want to make,
pass the case. You guys stay right where you are.
I don't want to make any misstatements on the record. If you just give me 1
No,
second.
I
Your Honor,
gotta take your
apologize.
time. You guys stay right there. Just mute yourselves,
Thank you.
Mr. Shazad. And then when I call your case again, you unmute, okay? Do I have Ronald Bodges here yet? Granite Valley versus Ronald Bodges, 2600973. Mr. McCardle,
Again, Your
your
Honor,
name?
Jim McCardle on behalf of the plaintiff.
So I'm curious, Mr. Bodges is not here, but I've never seen your office or other lawyers do this where they separate out. They file a termination of tenancy, then they file a non-payment of rent later down the road. I'm curious as to what the thinking was there.
Your Honor, I honestly don't know. I can't tell the court.
Well, do you think it's appropriate for me to give you a judgment?
On
Wait a
the
minute, Ms.
non-payment,
Bryant.
yes.
Now, Ms. Bryant, come on now. All right, you can disagree with me when we're done. It's all right. Well, go ahead, Mr. McCardle. Is that appropriate?
Yes, it is, Your Honor.
Well, I think under these circumstances it is because I indicated essentially I was staying the other case. You go ahead and spell out your terms. Mr. Bodges is late. He didn't show up. This was scheduled for 9:30, and you can go ahead and give me your figures. If you'll start with just rent to retain and then late fees.
Give me a second, Your Honor. They're lumped in. The rent to retain is $1,568.08. We have late fees of $35.
One late fee?
Yes, Your Honor.
Okay.
We have costs, the court costs of $191.07, as well as, and the total is $1,794.15.
Defendant failed to
Yes.
appear default. Go ahead. I'm sorry.
We're asking for a writ date of April 9th, Judge.
Writ date will be April 9th. Defendant failed to appear. I gave him 15 minutes. It was scheduled for 9:30. It's 9:53. So that's how I will handle that one. Ms. Borden, can you hear me now, ma'am?
Yes, I do. Can you hear me?
Did you guys chat with her and tell her she was going to have to appear if she couldn't get on the device?
Judge, I have been repeatedly chatting with her. I'm not getting any responses from her. I assumed that when she disconnected that she would be headed on her way here, but she reconnected.
What do you have to
So,
say, Ms. Bryant? Tell me your name. This is Granite Valley versus Pamela Borden, 2600975. Your name, Ms. Bryant?
Suzanne Bryant.
Ms. Borden, can you hear me? If so, raise your hand. But you chatted with, did her hand go up just now?
Yeah.
Show me again.
Yes.
You can hear me, Ms. Borden? If you can, shake your head up and down. Why can't we hear her?
I'm not sure, Judge. She's not
I'm
muted.
the last guy anybody should be answering to figure out a T question. So I don't know what to do.
Well, we worked out I'm sorry, Judge.
I know, but I can't do this if I can't communicate with her. So there's only one or two things for me to do. I'm either going to insist that Ms. Borden drive up here now. Is there any reason you cannot drive up here now, Ms. Borden? If there is a reason, then you go up and down with your head. If there isn't, then side to side. Can you come up here? Good. How far is that from here again, Ms. Bryant? 15, 20 minutes, right? Would you say?
Yes.
But
Yeah,
we don't have
that's-
Allen Road open. Allen Road is not open south of Allen. Okay, you can't get through on, I'm sorry, south of West. You can't get through on Allen Road anymore. If you're traveling southbound on Allen Road, it's closed right by the railroad tracks.
Right, Judge, she
Okay.
should be able to take Telegraph straight south.
Right,
to Van Horn.
Telegraph to Van Horn probably, right?
Correct.
Mr. McCardle, you can just log back in about 15 minutes. I'll wait for you, ma'am, okay?
Okay, thank you.
Thank you.
Thank you, Judge.
Thank you. All right, Williamsburg versus Salim Shahzad, 2601091. Mr. Shahzad, your name again.
My name is Salim Shahzad.
Mr. Baidoon, your name again.
Mohammed Baidoon appearing on behalf of Williamsburg LLC.
So you conferred with your office and they concluded I'm right, right?
You are right. You are correct, Your Honor. The
Okay.
payment was accepted for February.
So I'm gonna go ahead and dismiss the case. There's nothing short of me doing. You're gonna have to start the process over.
We understand, Your Honor. I did request, I understand, you know, if there's any way we could just extend this by 30 days, or does the case have to be dismissed and refiled?
I think it has to be refiled. If you guys want to do something, if you guys want to go into listen, Mr. Shahzad, I want you to listen very carefully. And if you don't understand something I'm saying, I invite you to interrupt me, okay? They did something they shouldn't have done. You can't send out a 30-day notice to quit, 30-day notice to quit and terminate tenancy and then accept payments. So I am going to dismiss this case. Now, that means they've got to start the process over. The other alternative, if you guys still want to do this, I'm not going to get in your way. If you want to just go into a breakout room and agree that you have to vacate on or before June 1st or May 20th, or I could care less when you come up with, I'll be glad to do that. So what is your preference, Mr. Shahzad?
I was willing to talk to them in the beginning, but they made me go to the court. But I am intending to leave this place the 30th of June. That's second option. Whatever.
Wait a minute. I just want to know, sir. Listen, I don't need to know any of this.
Yeah, I will leave June 30th.
You
Your Honor,
guys,
I know it's his request, but I do think it'd be in his best interest that we do go in a breakout room.
why don't you guys go in the breakout room and you can see if you can resolve it.
Thank you.
I'm only telling you, I'm either going to dismiss this case and make them refile, in which case they have to start the process over. Or if you guys choose to go into a breakout room and agree on a vacation, a date that you have to vacate by, that's acceptable to both of you, that's fine too. Do you understand what I'm saying to you, Mr. Shahzad? I want to make sure that I'm doing a decent job of conveying.
I appreciate that, and I would like to talk to the lawyer. If he doesn't, then I will request that you can dismiss the case for me.
You guys go talk in a breakout room and then you come out and you both let me know what you want to do, okay?
Thank you, Your Honor.
Thank you. Thanks,
Thank you, Your
Mr. Baidoon.
Thank you, Your Honor.
All right. Let's take Mr. Picardo. What did I do with Borden again? Oh, yeah. Thank you. Borden and Bordine, kind of close. Thank you. All right. What do I have now? Anything else down there? John?
Did you finish Bridgewood?
I finished. Yes. You're Miss Borden? No, you just look.
No. They're tennis.
I mean, really? Okay. All right. Silver Creek versus Jan Broadnax, 2601096.
Your Honor, I have not had Jan Broadnax sign in.
And is Mr. Butcher or somebody from his office here?
Yes, I just brought them in.
Okay. That's the manager, right? Sarah, you're the manager of Silver Creek. Let's see. So who's representing?
I'm bringing him in right now, Mr. Spinelli.
Oh, okay. Spaniola, I think.
Oh,
How you doing, counsel? Good morning. Your appearance?
Good morning, Your Honor. This is Attorney Paul Spaniolo, P72366, standing in for the attorney of record on behalf of the plaintiff.
All right, so Ms. Broadnax did not appear, but it was scheduled for 10. You know what? I hate to do this. If something was ready, I'd go forward, but I give everybody 15 minutes and I'm going to give her 15 minutes. Okay, so I'll be back here barring something else coming in earlier at 10:15. And I will.
Thank you, Judge.
Thank you all. Thanks. Stay seated, everybody.
Oh.
If I may, Your Honor, just ask Mr. Salim to stop attempting to make payments to my client, as my client will no longer be accepting payments.
Yeah, I'm gonna go ahead and dismiss this on my motion, and they'll have to start the process over. I'm sorry, you just can't do that. Thank you very much. But
Understood.
don't tender any more payments to them, Mr. Shazad. They're not going to accept them, okay?
Thank you, Your Honor.
Good
Thank you.
luck. What's that?
Thank you.
All right, let's take Borden. Granite Valley versus Pamela Borden, 2600975.
Again, Your Honor, Jim McCardle on behalf of Granite Valley.
Ma'am, your name?
Pamela Borden.
I don't know what the problem was with your device. Check your volume.
I've done everything on it too.
Okay, then, so from now on, if you have to appear on this again, you're probably gonna have to appear in person, okay? All right. Mr. McCardle, what would you like to say here? Does she still owe the 1835.64 plus the April rent?
No, Your Honor, we have a different figure. I can give that to the court. We have rent of $674.48 with late fees of $70 for a total of $744.48. We have court costs of $191.36 for a total of $935.84. Now, Your Honor, Suzanne Bryant, the manager, is with the court this morning, and she was informing me that we have some sort of an agreement. So if we can get Ms. Bryant.
Unmute, tell me your name.
Suzanne Bryant, Granite Valley.
Okay,
Yes.
tell me what the substance is.
So she's going to pay $745 today.
Is it, okay?
And then that'll leave a balance of $166.55, if my math is correct. And she's gonna pay that in the additional late fee on the 11th.
Well, wait a second. If she pays $745 today, she should owe $190.84.
Yeah,
For
but that's but she's gonna pay April's rent with it. So yeah, you could do just the March stuff. That's
Okay, you
fine.
really don't have April due yet. Now, if you want to,
We don't need to include it. That's fine.
okay,
She's
good
gonna do it
enough.
Anyway.
So, ma'am, so you want a judgment for the 935.84 then, right? With a writ date of the 9th, Mr. Mr. McCardle, sorry.
Yes, Your Honor.
You're gonna be able to pay the balance after you pay the $745 by the 9th, which is a week from Thursday?
I'll be able to pay that on the 10th.
I'll give you until the 10th then, okay? But then you're still gonna have April rent due, all right? You'll submit that judgment, Mr. McCardle. That'll be after hearing, okay?
I will, Your Honor.
Well, is it by consent? Maybe it's by consent. Yeah, we can just do it after hearing. Okay, do you understand everything, ma'am?
Sure do.
All right, you have any questions for me? All right, good luck. Thank you.
Thank you, Judge. Have a nice day.
You too, thanks a lot. FC Stratford, LLC Stratford Place versus Audrey Bagnowski, 2601097. Mr. Fantera, your appearance?
Good morning, Your Honor. David Fantera on behalf of the plaintiff.
Is Audrey Bagnowski out there anywhere, Jennifer or Linda?
She has not checked in with us, Judge.
You paid for a second mailing. You can take a default if you wish, Mr. Fantera.
Yes, Your Honor. The amount of rent that's owed is $1,595. There's one $75 late fee, court costs of $190 for a total of $1,860. We'd ask for a judgment for possession with a writ after 10 days if that amount.
Defendant failed to appear. Relief request will be granted. Default judgment of possession in favor of plaintiff and against defendant. The writ date will be on the 9th of April and the amount to be paid to save it, $1,860. I'm just going to ask you to get that to me as soon as you can this morning. So I try to get all these out of here. Okay.
I'll do it right now.
Thank you very much. Golden Management versus Elijah Teamer, Elijah Boyce, and all occupants. 2601099. Everybody's name.
Good morning, Your Honor. Patrick Fortuna appearing on behalf of the plaintiff. My P number is P81281.
Okay. Ms. Boyce, good morning. Your name?
Asia Boyce.
Is Elijah Teamer with you?
Yes, how you doing?
Not bad. How are you? Your name?
Elijah Teamer.
Did the two of you listen to the rights form on the rights on the video that were read to you, Ms. Boyce?
Yes, sir.
Mr. Teamer?
Yes, sir.
You wish to talk to a lawyer or apply for funding on this?
Yes, sir. I have did that. They wanted to see what's the next step. So they told me upload a judge letter because they want to see what's the next step.
I'm sorry.
Oh.
No, he's talking about do we want like
Oh.
lawyer?
Oh, I'm sorry. We can do the funding.
You're going to apply for funding.
Yes, sir.
Have you already applied?
I did 6 times. They want a judge letter.
I don't give letters. You can take the complaint over there.
Oh.
You can take the complaint over there and you can, they don't need a judgment to give you funding. But you have to provide us with proof that you've made application for funding within 7 days or 5 days of today's date. So you should do it by the end of the week, okay? And you should bring it into the courthouse. So anything you're applying for funding with, you're gonna have to do that in the next 5 days where you provide us with proof. Do you understand that, ma'am?
Yes.
Sir?
Yes.
April 13th will be the court date. At what time, Jennifer or Linda?
How about 9 o'clock, Your Honor?
Okay, 9 a.m. That will be the new date. Anything else on this?
The only thing I request, Your Honor, is Ms. Boyce, Mr. Teamer, if you can please contact our law office. Our telephone numbers on the complaint form and all the notices you should receive. So please contact us and hopefully we can get on the same page and just work this out.
Okay, no problem.
Thank you so much.
Good luck, folks. We'll see you in a couple of weeks.
Okay.
Golden Management versus Luella Morgan, 2601133.
Good morning, Your Honor. Patrick Fortuna appearing on behalf of plaintiff. My P number is P81281.
Good morning, ma'am. Your name?
Good morning, Luella Morgan.
Did you listen to and understand the rights on the video?
Yes, I did.
Do you wish to speak to a lawyer or apply for funding?
Not at this time, no, I don't have money.
I will note for the court, Your
This
Honor.
is not for non-payment. I just noticed that.
Yeah, this is a health and hazard matter, Your Honor.
And I appreciate you taking the time with me.
Ma'am, he's showing me pictures are attached to the complaint.
Yes. This is not me. Sorry I get emotional, but they've given me a lot of chances. The outside was winter with the snow shovels, and the inside is back in May, June.
All right, there's no reason to be upset. Do you have any?
Emotional, but
Do you have any children or anybody?
no, and I've never been.
Wait, slow down, just slow down. You go, hang on, ma'am, just wait, let me talk for a second. Mr. Crawford, I'm gonna ask you to take your hat off, please, sir. Mr. Fortuna, Mr. Crawford, can you hear me? Take your head off if you would, please, sir. Mr. Fortuna, how
Yes, sir.
bad is this?
From my understanding, it is a concern, with respect to the city. They've issued a notice that it's unsafe for occupancy. And then with respect to my client, they did complete an inspection before we started this current action and attached the related photos to the
Mr.
complaint.
Crawford, tell him to take his hat off. Will you guys please? You apparently can't hear me or. How long is it gonna take you to get the place cleaned up? If the city's complaining, well, why'd you wait so long?
Well, I have medical issues and,
Ma'am,
when.
just let me stop you. Did you guys hear me about Mr. Crawford, Jennifer and Linda? There you go.
Yes, I sent him a chat. There you go.
Thank you.
He must have got it.
Ma'am,
Okay, sorry, folks. I was having a
You're
difficult
fine.
hearing you.
you're fine. Can you take a week? Can I count on you to get it out of there? All that junk. And it is
Yes.
I can give you 1 week adjournment. And you gotta clean this up.
Yes.
But you gotta do it quickly. This is a fire hazard. The city already went out and inspected, right? You said that? I wanna make sure I understand you.
Yes.
That is correct, Your Honor. I do
Why are
have
you-
city notice.
April 6th. I'm adjourning this to April 6th. Any great objection, Mr. Fortuna?
No, Your Honor, that ultimately, we'd like to see the property get cleaned up. So that's completely
Ma'am,
reasonable.
Ma'am, will you please take care of that for yourself and for the court? Okay? What time are we gonna do this, Jennifer?
9:30, Your Honor.
At 9:30 in the morning. 9:30 in the morning, April 6th, 1 week from today, okay?
Thank you so much, Your Honor.
They'll give you a notice down the hall. Yes, ma'am. Thank you. Thank you, Mr.
So
Fortune.
much.
You're welcome. Make
Thank you,
sure you
Your
get it out of there, though.
I will. Thank you.
Thank you. Good luck. I wish you well. All right, I'm gonna call Douglas Heckert Jr. versus Amanda Potter and Eric Velke Jr., 2601-222.
Morning, Your Honor.
Hello,
Good morning.
good morning.
What's your name, sir?
Douglas Heckert.
Mr. Velke, you gotta start your video. Ms. Potter, state your name.
Amanda Potter.
Mr. Velke, your name.
Eric Welke.
So what's going on here, Mr. Heckert? You sent them a notice to quit?
Yes.
Under what circumstances are they staying in your property?
Good. I've been friends with them for a long time and, they haven't been able to keep up with their rent.
Do you have a written lease with them?
I didn't at first, but I made out a new lease agreement with them and had them go over it and sign it. And,
You're trying to do some, okay, when did they sign the lease?
yesterday,
You're trying to do something and, you sued for. I don't know what to do. You gotta be careful. I don't know why everybody thinks they can do this properly. Now, you've sued them for termination of tenancy, which has nothing to do with them being unable to pay the rent.
right.
And you could have asked for me to give you a judgment today, asking for them to be out by April 9th. And now you're telling me you entered into a lease agreement with them?
It's never really been a lease agreement. It's been
No, listen, did you not tell me you just,
yes, yes.
yesterday?
Yeah, yes.
What are you doing?
Trying to, they want to be able to stay. And they have so much back rent that they owe. And I had made a agreement to where they can stay and I will not evict them as long as they abide by the new lease that I had given. First part of this, when I filed.
You're trying to be your own lawyer and you're not doing very well at it.
Right.
What do you want to do with this case? Dismiss it? Now you got a regular termination, I'm sorry, a regular lease, and now if they don't pay, you can send out a 7-day notice to quit and you can have them evicted. I'm just telling you.
Right. So, yeah, pretty much.
I don't know what pretty much means. Do you want to dismiss this case? You guys,
Dismiss this case, and then if they break this lease agreement, I will be back.
you're gonna have to file it separately. I'd suggest you get a lawyer. It should be for non-payment of rent if you just entered into a lease. How long's the lease? 1 year?
No.
You need to talk to a lawyer. I'll be glad to dismiss this case for you. If that's what you want, everybody agrees to it, I'll dismiss the case. Is that what you want?
Yes, I also have a question.
Okay, I wasn't really talking to you yet. I'm asking him. Is that what you
I'm
want, is to dismiss this case?
No.
Oh, come on. I don't know what you want out of me. What, I can't, you just entered into a lease agreement with them. You're trying to do something you have no business doing. This isn't a small claims action. You just don't have any business doing this. I don't know what you want me to do. It doesn't sound like you guys have been fair with him, though. I can tell you that if you haven't been paying. How long since they paid you rent?
I haven't received, they're pretty much like 10 months behind.
10 months. Wow.
That's completely
$600.
What a great country when we can get 10 months of free rent. I hope my bank's gonna give me 10 months of free mortgages. How much you owe him, Ms. Potter, Mr. Velke? What are you guys doing? You taking advantage of a friendship, or you guys just not?
No, we're
going out
2
and
months,
working?
we're 2 months behind rent.
Well, you,
They are not too much money.
so wow, you guys are quite.
They have a balance of 3,000.
We're not gonna go there. We owe money. We know how much money we owe. We signed an agreement, plain and simple. That's
How much do you owe, How much do you owe, Mr. Velke?
$3,400, and it's more than just rent. It's for other things too. It's personal.
How many
things.
months are you behind on rent, Mr.
10
Velke?
months of rent.
2.
6. I'm sorry?
2.
How many months are you behind on rent, Mr. Velke?
We haven't paid anything in 2 months.
Just 2 months. You guys are off. How are you accepting your payment? This is what I'm talking about. You taking it in cash and not giving receipts? Are they giving you money orders, certified checks?
Yeah, so
No.
Nice, nice. Let's make sure we really complicate this. I mean, seriously.
I tried to do it. Right.
Well, you didn't do a very good job. You're hurting yourself. You cannot be your own lawyer. I mean, you
I'm not
can't.
trying to be my own lawyer. I'm trying to help out some people and they're taking back.
Well, I mean, that kind of seems like that to me, but you got a warrant for your arrest, Mr. Velke. You know that? I know. Everybody's always so shocked. Like it couldn't happen to me. I've been a choir boy. Where haven't you shown up on your warrant?
I don't even know what you're talking about. How old is this?
Don't know, Mr. Velke. I just do what people ask me or inform me of, and they just told me you've got a warrant out for your arrest.
I have no clue. I had a misdemeanor warrants. I took care of most of them.
Most of, oh, okay. I want you to tell me what that is, Linda, or somebody over there. You got one in front of Judge
I'm sorry, Your
Heston?
Honor.
What is it, for unpaid fines?
I don't know. Sorry, I didn't catch what you were saying.
Don't worry about it. How much, oh, you got a 5,010%. Do you work, Mr. Velke?
No.
Why not? You're not disabled, are you?
No, I do like odd jobs here and there. I'm looking for back full-time employment.
All right, listen.
All right, Judge, their rent is $400 a month.
I don't,
And they're fucked behind. If they're trying to state that they.
Sir, you got a mess.
Yeah.
You've got a mess. I'm not addressing non-payment of rent. You didn't sue him for non-payment of rent.
Okay,
You sued him to have him evicted because of termination of tenancy, and then you, for whatever reason, decided to go enter into a lease agreement with them yesterday. I don't know what I can do here. If you've got a valid lease, you have no right to evict them. The only thing I can do is dismiss this case. You need to get a lawyer helping you, sir. I mean, I don't know what the situation here. I feel bad for you. I really do.
Stating you're only 2 months behind, I just better go through with the proceedings of having them
You,
evicted.
you can't. You just entered into a lease agreement with them. You guys aren't being honest. I can tell. I can tell by talking to you. You're not being honest, neither one of you. Shame on you. Shame on you. Do you work, Ms. Potter?
I'm on disability.
You guys are not being honest with me. I'm just so confident that I can say that. I can just tell you're not being, don't act like you're a choir boy, Mr. Velke.
I don't know.
I expect you to come up here and take care of that warrant in the next 2 hours. You understand?
Wait, what?
Wait, what? I expect you to come up and take care of this warrant that's been outstanding for almost 4 years now. Are you with me? Today, within 2 hours. You're not working. You're not doing anything. You're sitting at home. I expect you to come out here, and don't be shocked if you don't. If I call the police and say, go pick up Mr. Velke, in which case we'll get around to hearing the case when we feel like hearing the case. So here's what I'm doing. You don't leave me any option. I'll give you a 1 week adjournment and you can talk to a lawyer. How's that? But you better do it because you're really making a mess out of this thing so far. April 6th at what time?
9:30, Your Honor.
At 9:30. I would strongly suggest you do that, Mr. Eckert. And I'll just make a note. You could have terminated the tenancy if you didn't get the wise idea of doing that lease yesterday.
I only did it because they had nowhere to go.
Listen, I commend you. I think you're a nice man. You seem like you're very nice. You're trying to do some friends favors, and this is the problem. They're not really friends. They're not friends. Friends don't do this to friends. So now you're starting to take matters into your own hands. You're executing lease agreements. I don't even know how good or bad it is. I'll adjourn this 1 week. Is 9:30 okay, Linda?
Yes, Your Honor, that's perfect.
April 6th, 9:30. I'll tell you what, Mr. Velke, if somehow, some way you don't get up here in the next 4 hours or 2 hours, Mr. Velke, to appear in person, you are to be here in person next week. So if I were you, I would come up here and I would take care of that warrant by 1 o'clock at the latest. It's about 10:43 right now. You understand what I'm telling you, sir?
Yeah, I'm going to work today, so I'm gonna have to.
Mr. Velke, I can only tell you, do what you gotta do. I'm only telling you, if I were you, I'd get my tail up here and you take care of that warrant by 1 o'clock. Don't tell me this, I'm going to work today. You're not working. You just got done telling me that for the most part.
I told you.
Mr. Velke, Mr. Velke, I will remember you. You will be here in person next Monday, or I'm going to send them out for you. And you're going to end up defaulted on this case. I'm not going to argue with you. I expect you here in the next 2 hours. Good luck. We'll see everybody next week here at that designated time. Secretary of Veterans Affairs versus Jason S. Crawford, 2601134.
Thank you, Ron.
Thank you. Mr. Tuma?
Yes, Your Honor.
I have a feeling yours kind of went to the back end, Mr. Spaniel, and I feel bad for you. I promise you that'll be next. Give me Jason Crawford.
He was stuck in the breakout room. I'm bringing him in right now, Your Honor.
Your appearance,
That's
Mr.
Douglas Tuma, P53-610 on behalf of Veterans Affairs.
Good morning, Mr. Crawford. Your name?
Jason Crawford, Your Honor.
Did you listen to and understand the rights on the video?
Yes, I did, Your Honor.
Uh-oh. You wish to speak to a lawyer?
No, I do not, Your Honor.
Did you guys talk, Mr. Tuma?
We have not talked yet, Your Honor.
So do you agree with all this, Mr. Crawford, that you're holding over, that it went to a sheriff's sale and the redemption period expired?
Yes, I'm aware of that now, Your Honor.
How much time do you need to get out, Mr. Crawford, if you're still in?
If, I don't want to put any folks out any more than it has to be, if 30 days would be acceptable,
We would do a consent judgment for 30 days. We want to do what's right by you two.
okay, thank you.
So he's willing to do a consent judgment with you. And that consent judgment will set forth that you have to vacate on or before April the 3rd, correct, Mr. Tuma? Or 29th?
If you said the 30th, yes. Or the 29th, correct, yes.
Yeah,
April 29th.
so do you agree to that?
Yes, Your Honor, I do.
Since you're unrepresented by a lawyer, you have 3 business days to come in here and fill out a motion to set aside the judgment if you don't understand something, and you have 10 days to appeal. Do you understand that?
Yes, Your Honor.
Does Mr. Tuma have your permission to sign your name to a proposed consent judgment that will be submitted to me calling for a writ date of April 29th?
Yes, Your Honor.
You fully understand everything?
Yes, I do.
Any questions at all?
No, sir.
All right, so Mr. Tuma, you can submit your proposed judgment. Sir, I sincerely wish you well. April 29th, you have to vacate by,
Thank you,
okay?
Mr. Crawford and court. Your Honor, do you prefer my file system or do we submit directly?
File, yeah. I mean, I prefer the old way where I'm signing judgments, but
Yeah.
they don't give me any choice. Yeah,
Okay.
you submit it on M-File. Thank you.
Thank you.
Antoinette Arnold, good luck, Mr. Crawford. Tanglewood versus
Thank you.
Antoinette Arnold. Oh, wait a minute. Hang on a second. Jeez, give me a second here. Where is Silver Creek? That's what you had, right? Right, Mr. Spaniola? Silver Creek versus Jan Broadnax. My apologies. 2601096. Your appearance?
Thank you and good morning to you and your staff, Judge McNally. This is Paul Spaniello. My P number is 72366. I'm standing in for the attorney of record on behalf of the plaintiffs.
Do I have anybody here for Broadnax?
No, Your Honor, I have had no one check in by that name.
So you're entitled to a default judgment. You can go ahead and give me your breakdown.
Thank you, Your Honor. Respectfully, I'm moving for a default with the following terms. Rent to retain is $1,016.20. Cost $178.54. And if my arithmetic is correct, that would be $1,194.74 with the redemption date of April 9th, Your Honor, if signed today.
Do you have late fees included in here?
There was 2 late fees of $50 each, Your Honor, for 2 months.
So actually, it's $916.20 to retain, rent to retain, right? And then $100 in late fees?
Forgive me, yes, I did fail to
All right.
bifurcate that out. Yes,
In your total's $1194.74.
74.
Judgment will enter. Writ date will be April the 9th. I'm gonna ask you to send that over if you would, please. And
Yes,
it's
Your Honor.
$1194.74 is the amount to be paid to save it from the writ issuance of the writ. Sorry, we got you so backed
No,
up
no
here.
worries. Thank you so
Have a
much.
good-
Good seeing you.
You too. Take care. Have a good
Like-
day. Thank
You
you.
too.
Okay, I want to take Meadowlands first. Meadowlands versus Kevin Burke, 2601156.
Your Honor, Attorney Ian Morton, Appellate's Law on behalf of Meadowlands.
Do I have Kevin Burke out there?
No, Your Honor, Kevin Burke has not checked in.
Paid for a second mailing. You can go ahead and take a default, Mr. Morton.
Your Honor, at this time, we would ask a default judgment for possession be entered. Rents retained, $3,738.25. Late fees of $40 for a total of $185.04 for a total of $3,963.29.
Now, let's slow down. You said $40 a month for a total of 185 something.
Your Honor, if we could pass that one, I'm realizing that the numbers they gave me on that one are a little.
Meadowlands versus Christina Kaliba, 2601159. Is Christina Kaliba here?
No, Your Honor, she did not check in.
You can go ahead. You paid for a second mailing on this. Are you ready to do these or do you need?
Yes, I'm
more
ready
time?
on this one, Your Honor.
Go
Yes.
ahead.
Your Honor, this one, was it
Appearance.
rents retained, Attorney Ian Morton Palace Law on behalf of Meadowlands. Rents retained, $723.54. Late fee, $40, because it's one late fee. Court costs, $185.04. Total, $948.58, Your Honor.
All right. Default judgment will enter. Writ date will be on the 9th of April. The amount to be paid to save it from the issuance of the writ is $948.58. Meadowlands versus Noah Lohr and Heather Lohr, file number 2601160. Appearance.
Your Honor, Attorney Ian Morton of Palace Law on behalf of the plaintiff. Your Honor, at this time, we would move to dismiss this matter without prejudice.
Case dismissed, motion of the plaintiff, and you're going to submit your order today, true?
That is correct, Your Honor. I think I dismissed at the end of the day on Friday, so I understand why the court, I take that back. It was just dismissed this morning. So yes.
No problem.
Dismissal's been submitted.
Okay, Meadowlands versus Gail Tittle, 2601165.
Your Honor.
We have Patricia Pishlow as an occupant, Your Honor. Gail Tittle is deceased.
Ma'am, your name?
Patricia Pishlow.
Good morning to you, Mr. Morton, your name?
Your Honor, Attorney Ian Morton of Palace Law on behalf of the plaintiff.
Did you listen to and understand the rights this morning, ma'am?
Yes, sir.
Do you wish to speak to a lawyer or apply for funding?
No.
Mr. Morton, can you tell me how much is owed, just the total balance right now?
Total balance, Your Honor, is $1,117.99. So 1117.99.
Do you agree that you owe that amount, ma'am?
Yes, sir.
Can you pay that?
I am planning on paying it, but on Thursday of this
What do
week.
you want to do, Mr. Morton?
Your Honor, the court would like to, was it based off of the deceased issue as well? The court would like to adjourn this. Was it one time? We'll see if she pays. If she pays, good. If not, then we'll move forward at that point.
The only problem is when you say you're going to pay by Thursday, you're going to have to pay the April rent by then.
Correct. Right.
I'll be glad to give you an adjournment to April the 6th. What time are you going to do that, John or Linda?
9 o'clock. 9
At
o'clock.
9
Your Honor.
a.m. Okay, so make sure you get your 11, whatever it was, 1117.99, I think, plus your April rent together. And if you pay that by Thursday, he should hopefully submit a dismissal and I'll sign it. Okay.
Sounds good. Thank you.
Have a great day.
You too.
Meadowlands versus John Wood, 2601167. Is Mr. Wood here?
No, Your Honor, Mr. Wood has not checked in.
He paid for a second mailing. Go ahead.
Here at this time, we would ask a default judgment for possession be entered Attorney Ian Morton of Palace Law on behalf of Meadowlands. Rents retained, $671.11. One late fee of $40. Court costs, $185.04 for a total $896.15.
Default judgment will enter. Writ date will be on April the 9th. The amount to be paid to save it is $896.15. I'll ask you again to submit that this morning. You want to go back on Wirtz or Burke, or do you need more time?
I'm going to need about 1 minute on that one, Your Honor, if I can sit down and look at the numbers.
Let's do this. Let's go on Tanglewood versus Antoinette Arnold, 2601153. Is she here, Linda?
Your Honor, if I may, Miss Arnold was here. She did let me know that she did have a job interview at 11 a.m. So I think that's why I do not see her anymore. She was here just up until just a few minutes ago. So it's up to you what you want to do. She was here though, and she did see the video.
Counsel, what do you want? I mean, I'll give you a judgment if you want one, whatever you want to do.
Your Honor, was it, from my understanding, I think she may have been trying to get assistance. So we're okay to give her the one adjournment and see if she shows up the next hearing. If not, then we'd seek the default.
So we'll defendant here but left. I'll make a note. Job interview. I'm going to adjourn it 2 weeks. We'll adjourn it until the 13th. At what time, John?
9:30, Your Honor.
At 9:30, and I'll make a note that defendant conveyed to you, Jennifer Michelos.
Yes.
She will apply for funding. So I'll do that, okay? Now I also have Tanglewood versus Marshall Shearer, 2601155.
Defendant has not checked in, Your Honor.
You can take a default on this.
I do intend to proceed with that default, Your Honor, if I may.
Go ahead.
Your Honor, was Attorney Ian Morton, appellate on behalf of Tanglewood, rents retained $626.03, one late fee of $50, court costs of $190.04 for a total of $866.07. So 866.07 non-payment rent possession only.
Good enough. Default judgment is
Judge,
entered.
I do apologize. If I may interrupt both of you, Mr. Shearer did just appear in our waiting room. Would you like me to admit him?
Sure.
All right.
Mr. Shearer. Who was Mr. Shearer?
That's the one you just did, sir.
It's 01155 LT, the one we just started to move forward with the default.
Mr. Shearer, start your video, please. But I'm going to go ahead and take your judgment on the other one here. Well, Mr. Shearer, you got to start your video, sir.
Yes, I'm trying. I don't know how.
You're late.
Yes.
Why?
I couldn't get the Zoom to work. How do I don't know how to do this.
If I may, there should be a small icon of a video camera in the bottom corner. Just touch that, or there may be a circle with a dot in the middle of it that will give you your options to start your video.
Do I have Woodhaven Plaza? Anybody here for them?
Okay.
Your Honor, there was a dismissal filed this morning on that. It is in your box to sign, by the way.
Case dismissed. I'll sign the judgment. So that is on Woodhaven Plaza LLC versus Right Turn Driving School Inc. 2600960. And we will go from there. You ready on Burke, Mr. Morton?
I'm going to be ready in 30 seconds. I'm the only one doing the calculations right now. So
Problem.
it's going to be
All right, I'm gonna go back on Marshall Shearer. This is Tanglewood versus, I'm sorry, wait a minute.
Yes.
Hang on one second, let me find it. I lost it now. Which one is, oh, Meadowlands. No, wait a minute. Sure. Okay, here we go. Tanglewood versus Marshall Shearer, 2601155. Your name, please?
I'm Angela Day, but it's under Marshall Shearer. He doesn't live here anymore, but I can't change the lease. I'm his daughter.
How long have you been, Mr. Morton, your appearance?
Your Honor, for the record, Attorney Ian Morton, appellate on behalf of Tanglewood.
Okay, identify yourself again, please. I didn't catch your name, ma'am. I need your name again. All right, here's what I'm doing. Council, I'm gonna adjourn this 1 week. We'll adjourn it 1 week. At what time is Mr. Morton's office showing up on these again?
I believe it was 9 o'clock, Your Honor, on 4/6.
Defendant occupant to appear in person. So you're gonna just put must appear in person on their notice, okay? We'll adjourn it 1 week to 9 o'clock, April the 6th. And then that should be it, other than Burke.
Yes.
Meadowlands versus Kevin Burke, 2601156. All right, counsel, your appearance.
Your Honor, Attorney Ian Morton of Palace Law on behalf of the, was it plaintiff
All
Meadowland?
right, give me your breakdown. Mr. Burke is not here, so I'm gonna give you a default.
Your Honor, rents retained is $3,528.25. Late fees, $250 and $50 each for 5 months because he is significantly behind.
Okay,
Court costs $185.04 for a total of $3,963.29.
defendant failed to appear. Default judgment will enter. Writ date will be April the 9th. The amount to be paid to save it from the issuance of the writ is $3,963.29. April 9th will be the writ date. Okay, ma'am, I don't remember what your name was, but I'm not gonna have us go in and out like this, so I'm gonna have to have you appear in person. So that was that. Listen to me. Tanglewood versus Marshall Shearer, 2601155. You need to tell me your name again. I'm adjourning this to April the 6th. April the 6th at 9 a.m. That's the best I can do, Mr. Morton. I'm sorry. She must appear in person. Make sure that the occupant or any party, or Marshall Shearer, whoever's there, appears in person.
Your Honor,
I
will
will,
make a
Your
note of
Honor.
that.
Okay.
Understood, Your Honor.
Don, did we have, a sign on the AS?
I didn't, on there, but you can't have it.
I know.
I'm ready to just, just be super quick with you on this.
You didn't say.
On Bennett, you wanted us to reset this case to get the lab report. And I think Erica is saying that the lab is not ready on the DWI. And then that's one of the ones you said the request for that. I'm 100% sure. Ms. Bennett? Oh, I'm sorry. You said Ms. Bennett. Yeah, you called the wrong person. Porter, my bad.
He was busy talking to somebody else about another case, huh?
Yeah,
Came up here.
Philip Bennett is an MTRP. And the judge specifically said that he wanted the lab report to come back on the DWI as being the underlying offense. And as of right now, the DWI, I'm just used to it.
Yeah, they're running behind on some of the.
As of right now, look, that's what it said.
I believe it.
I was in March.
Yeah, with pending DWI, they can't go safety yet, right?
Correct, because we're gonna do safety.
Are we?
So that's what that was the game plan, but that you wanted the underlying. I could be wrong, Judge, but I'm almost positive you said that we want to see the underlying test. And then when I spoke with Ms. Porter, she said that the test isn't in yet.
Yes.
So I guess in about a month it should be available, but I know the court wanted the test. And that's on Mr. Bennett's MQRPs.
Okay, was a DWI charge, formal charge file?
Yes, sir. I think it's in, what court you in?
That's in a misdemeanor for what I presume.
Yes, sir.
Okay.
Who's court?
They haven't disposed of it.
No, they have not. He's not pled. I know. He haven't pled on the.
What is the word on the time period for the blood warrants and breath tests to return?
Judge,
What is it
sometimes
today?
Today. Okay, well,
As of today, what's the most recent time period? Do we have an idea?
That's just a Laird question.
it varies between 8 and 9 months, but I can call up the
8
crime lab.
or 9 months.
I was in drug court. That's typically how long
Wow.
it took for the labs to come back, but I can call
Wow.
the crime lab and check.
Birth a baby by then.
Yes.
Huh. All right. All right. Well, we're just gonna keep it
That's cool.
pending and review it every 4 weeks, I guess, huh?
That's fine.
All right.
That's cool. Thank you, Judge.
Let y'all have a better idea.
Not at this time. My idea was TDC, but we'll wait, see what the lab says.
Try to work it out.
Okay. Okay.
Ronald Cole.
Judge, on him, if you look at it, yes, sir. If you look at those cases.
I'm looking at it.
Yes, sir. Yes, sir.
Those are two false. Is that he?
That's false. That is a 2019 case, and the reason that case is so old, to my understanding, Mr. Post was in Montana and in Nevada, and they just brought him back.
I mean, what he's a transient. I mean, they blend into the woodwork, and it's hard to find a transient.
That is true. So what I wanted to do, since they just got him.
Let's see, what do we have?
It has 2 cases.
Two assaults on public servants.
Yes,
they're
sir.
different. And they're different. Let me read this.
A 2019 case.
See something.
Okay, yeah, and you should have it, but I'll look. Let me wait. Before you go. Changes in manifest.
Okay, the mystery deepens. Just a couple of things here. Mr. Pulse is charged with assaulting two public servants. I have a probable cause affidavit in the wrong file here that states Doug Soper was injured. I do not have anything on any probable cause documents. At all I have is stand by. Yes. All I have is a probable cause affidavit about 3 times. The copy that states Ray Wilson was struck, but Ray Wilson's name is misspelled in the indictment. What are we going to do about that?
Okay, it appears that the probable cause affidavit, the original indictment under 34881 was for Doug Soper. It was re-indicted, and I have Ray R.A.Y. Wilson. I'll check on this.
I don't have a re-indictment. I just have one indictment. On Doug Soper as the complainant, but Wilson only had one indictment on it.
Does Wilson on the front of the say re-indictment?
Yeah, but his name is misspelled.
Okay, we've moved to spell that correctly, Judge. That's a typo. I think.
Well, it's spelled twice. Ray Wilson, correct, and then about 7 words later, Ray Wilson, incorrect. It's obvious, I believe. I don't think there's any question when it's clear that it's a mistake. I mean, it can't be anything other than just a mistake. I'm going to correct his last name to Wilson rather than the way it is spelled in the second version of his name, which obviously indicates a mistake, which is fixable. Any objection?
No.
That is corrected. This date. 3:38. And this is 2026 already. You okay there, Ben?
I'm good. I was too busy watching that Duke game yesterday.
My dad used to say you can't get up and soar with the Eagles in the morning when you're hooting with the Owls all night.
I know, right?
All right.
It was a good game, though.
Okay, that is corrected. And as you know, Mr. Pulse, you're looking at a 3rd-degree felony in each case which carries with it up to 10 years in prison.
Not guilty.
Look, I'm not. It's not a debate. We're not in trial. I'm informing you like I have to inform all defendants what they're facing as potential punishment if convicted. You understand? That's all.
Judge, the case with Officer Soper as the victim, that's being dismissed because it's a re-indictment with Mr. Wilson being the actual victim. So we have to dismiss the one.
So 234881 is to be dismissed.
It is.
And we're just going to proceed on this one case 35175.
Correct.
Yes, what you need to do is just stay quiet. Don't say a thing. They keep dismissing your cases. I'd stay quiet and see what happens next. I think this one looks, I'm looking at it and I can see that this is, this seems pretty certain to move forward. But, okay, Langston.
Judge, if you don't mind, can you just put it on one more announcement and then and
How
I'll
much time? 4 weeks. 4 weeks is perfect. 4 weeks good for everybody. Look, I'm going to ask for Mr. Pulse. He's a transient. Does Mr. Pulse have any record? Y'all see a record at all from the state? Because it's not listed. Nothing is listed in the indictment.
Right.
And the injuries to this man was what? Was he? It wasn't serious injury.
No, we're not alleging serious. He has multiple arrests,
You know
but
what? On that case that's being dismissed, I need to pull that probable
From the
cause
law.
affidavit out of it because it
He was in the.
could be in this one.
dispositions. There's multiple arrests from stemming from Nevada, Las
Doesn't
Vegas.
make a big conviction.
Yeah, yeah, I don't see any convictions, but my offer reflects that.
4 weeks.
4 weeks, I think we'd be good.
How long have you been in jail? How long have you been in jail?
2.5 weeks. You just got it. Well, Montana. Yeah. No.
What were you in Montana for?
You must have lived there.
No. Why were you in Montana? Is that where there was a warrant that was sent for you or were you at the Montana jail?
I lived there, I got pulled over my car.
Yeah.
They said I was warrants in Jefferson County.
Okay. And then they put you in custody. When did you get arrested?
What?
When did you get arrested up there? About 2.5 weeks ago?
Yeah.
Oh, okay. Okay. I thought you had been in jail a while, but just 2.5 weeks? Okay. All right. Then set it for 4.
That'll work.
Thanks. Okay.
Thank you. All right, Mr. Foles, thank you.
Hey, Don.
Yes.
Hey, let me ask you. Where do you see meal on? Either the oil, that's where we said. We can reset.
Yeah, a couple of you.
I understand. Let me look at some of this. You're welcome.
Go ahead. Don, Daniel Berry.
That one needs to be brought out. It's gonna go on the trial docket.
Oh.
Daniel Berry. Something before you just mentioned was just reset with 2 weeks.
You're Daniel Paul Berry.
Yes.
In 26 CR 275. Mr. Dusler is here. Okay, you're charged with 2nd-degree felony of aggravated assault with a deadly weapon here. And paragraph 2 goes on to state that out of the court next door, 252nd District Court here in Jefferson County, Texas, you were convicted in 2020 for a robbery. So you were convicted of this new indictment. This robbery conviction is proven true. You're looking at up to life imprisonment. Do you understand? It's that simple.
What did we just, that's all? He's
I
asking.
said, you face up to life imprisonment.
I understand.
That's what I said in English.
He's asking the case be set on the trial docket
All right,
and that I be replaced so he can get to work quicker.
With
With a new attorney. He's asking that I be relieved so that he can go to court proper.
that won't get it any quicker. It'll get in the queue and it'll just be in the queue. I'm not gonna move them up just because of somebody who's on the trial docket, but
he is,
it won't get up. Now with our backlog, it doesn't get there quicker. It's just gonna be in the queue and it'll come up when it comes up.
but he's still asking that I be relieved, John.
It just costs the people extra money that they don't find amusing, and you can try it. So you're there. You know that. Who's next up on the,
Judge, I'm not sure.
you don't?
Back and look. We don't have a whole lot of people on all wills. So.
Yeah, that's a problem. That's another problem. Put whoever it is up there on it, okay?
There.
Aria LaCase.
That's a plea, he heard Ryan.
Here's
Is that? Yes, I even thought of nothing more.
I didn't see it, but that's just. Oh, you're
Yeah,
me.
your lady got a credit.
Please raise your right hand. You swear or affirm to tell the truth, and the truth, and nothing but the truth, so that is okay. And get your right down first. Okay, place it flat right here. Okay, you get up one more time. And. Let's get. Okay, and go to the 100.
Right here, please. Thank you. We now call cause number 26 CR 59. The state of Texas versus area.
Area.
The emphasis is on the second part of your name, right? Lacaz. Lacaz. You are here with Mr. Dusler, your attorney and the state's attorney. Does the defendant waive a formal reading of this indictment and the arraignment here? Can we proceed in summary?
Yes.
In summary, this indictment alleges that on or about December 20th, 2025, a few months ago, in Jefferson County, Texas, you committed the first-degree felony of aggravated assault with a deadly weapon, namely a knife. Do you understand what you're charged with here?
Yes, sir. Yes, sir, Your Honor.
There it is.
Since this is a first-degree felony, you are facing a term of life imprisonment if convicted, or any term of not more than 99 years or less than 5 years in prison. In addition, a fine may be assessed not to exceed $10,000. Do you understand the punishment range you are facing here?
Yes, sir, Your Honor.
An agreement's been reached where you would be pleading guilty and placed on deferred or unadjudicated probation. So, and that can be up to 10 years in length. There is no fine. Is there any restitution? Somebody was stabbed.
There's no restitution. The victim just requests mental health assistance. So I spoke with probation and we're going to do an evaluation and try to get her some help on that side.
Okay, but what happened to the victim? Did he have to go to the hospital or something?
He is not requesting or did not.
What I want to know is if we went to the hospital, did the people pay the bill, or is he just, if they're fronting the bill, then she's got to pay the people of this county. That's what they want. They don't want to pay for other people's mistakes. They're paying taxes high already.
Sure did go to St. Louis.
Yeah. Something that wasn't for free. There's some cost there.
I'd have to reach back out to him, Judge, and get the actual restitution amount then for his visit.
Well, it may be he may not even know. You know, he may walk out of there after they treated him.
Yes.
And then, but I know hospital puts it on the book somehow as an expense. And if there is, the people aren't going to absorb the payment by high taxes plus high medical costs for our insurance that we all pay for, because people are intentionally stabbing others, and then the treatment is absorbed by the people, which they don't find amusing nor fair. And I agree. I mean, if there's restitution, you're gonna have to pay. Do you understand?
Yes, sir.
When I'm, this is gonna be up to 10 years. And you do well, it gets shortened to 1/3 the time, which is 3 1/3. If I follow this agreement, you have no right of appeal of your case. Do you understand?
Yes, sir.
Okay. How do you plead to this charge of a first degree felony of assault, aggravated assault, guilty or not guilty?
Guilty.
Are you pleading guilty voluntarily? That is on your own free will and because you are guilty.
Yes, sir.
We'll show you what's marked as State's Exhibit 1. Did you sign that document voluntarily? Understand it? Discuss it with your attorney? Are the contents all true and correct?
Yes, sir.
State's Exhibit 1 is tendered into evidence.
No objection.
Without objection, it's admitted. This states that you are mentally competent to enter your guilty plea. It's freely and voluntarily made. You know what you've been charged with. The indictment's been read to you. You read it. You were guilty of the crime charged in any lesser included offenses. You were giving up your rights to a jury trial and the rights to the appearance, confrontation, cross-examination of witnesses. And you were totally satisfied with the representation provided by your lawyer. All of this so help you God.
Yes,
Correct.
sir.
And you are pleading guilty today voluntarily, knowingly, intelligently, and after discussions with your attorney?
Yes, sir.
All right. The pre-sentence report waiver.
Yes, sir.
You're going to follow this agreement and find you are mentally competent to enter your guilty plea. It's freely and voluntarily made. You know what you've been charged with. The indictment's been read to you. You've read it. You are guilty of the crime charged in any lesser included offenses. You are giving up your rights to a jury trial and the rights to the appearance, confrontation, cross-examination. You were totally satisfied with the representation provided by your attorney?
Yes.
All of this is true. So help you God. State's Exhibit 1 is made a part of the record for all purposes and pre-sentence reports.
Yes. Yeah.
I'm going to follow this agreement and find you. You are mentally competent to enter this plea, which is proven and voluntarily made. There's sufficient evidence supporting the plea from State's Exhibit 1 admitted here to find you guilty beyond a reasonable doubt. However, based upon the agreement reached, I am going to defer or postpone any finding of guilt so long, conditioned upon you following these terms and conditions of probation, which the probation officer is going to go over with you. Make sure you follow them, because if you fail, your probation could be revoked. You could then be found guilty and sentenced up to life in prison. Do you understand? No less than 5 up to life in prison. So there's a premium here on the requirement of you to follow these rules and conditions of probation. Restitution, it's stating none. There could be restitution just to what may be Christus or some other entity or people who absorb the cost for this intentional crime. And that's only fair that you, the responsible person, in all cases who make a mess and admit to it, you have to pay the costs back. The people who are involved in it shouldn't be paying the way for anybody else's mistakes. And that not only goes to you, for me, and for everybody else. We're all responsible for fixing our own messes. And that will be included. I'd like to know where we stand on that, because the court, unless something is happens, we find out that we don't know about, that defies logic, something, this costs. It all, hospital treatment always costs. It costs someone. This is an intentional act that you're going to have to repay somehow. You understand? So restitution will be ordered in an amount to be determined after the probation office does a post-sentencing report for it. Okay. Make sure you follow this and you move on with your life and make better choices. Anything else? No, that is something. Thank you. You got something else down?
I guess I'll have that.
Let's see. I'm beyond, but Larry McCarter.
Yes, sir, that's good. That's what.
Larry Dean.
Yes. Sir.
Okay. Twenty-two 40247 is now called, State of Texas versus Larry Dean McCarter. That is you.
Yes, sir.
Present with your attorney, Mr. Dusler, and the state's attorney. There is a first amended motion to revoke unadjudicated probation that is currently on the table here and is set for disposition today. Are we able to proceed today?
Yes, sir, we have an agreement.
All right. Raise your right hand, Mr. McCarter. Do you solemnly swear or affirm any statement you make during this hearing shall be the truth, the whole truth, and nothing but the truth? So help you God.
Yes, sir.
Lower your hand. Can we proceed in summary?
Yes, sir.
Does he waive a formal reading of this first amended motion?
Yes,
sir. In summary, this motion alleges that on May 15th, 2023, in this courtroom, you were placed on 5 years deferred or unadjudicated probation for the state jail felony of burglary of a building. Is that true?
Yes.
Oh. Stand by. What are we going on? First amended one? That's fine. First amended one. It's the third one, but it's called first amended. The first one under the first amended subpart of this motion. This alleges that on or about December 2nd, 2023 in Harris County, Texas, you committed the offense of aggravated assault in violation of condition 1 of your probation order, which states do not commit an offense. Is that allegation true?
Yes.
Was there any proceedings in Harris County over this?
yes, sir. He was for a 5-year sentence.
All right. So you understand what you're charged with here?
Yes, sir.
Is this allegation true or untrue?
True.
Are you pleading true voluntarily and because it is true?
Because he's true.
You understand that a voluntarily and knowingly made plea of true to one or more violations of probation, that's enough to grant a motion to revoke probation. Your probation can be revoked and you can now be found guilty of this underlying offense of burglary of a building that you were placed on deferred or unadjudicated probation for, and you can be sentenced up to 2 years in the state jail.
Yes, sir.
Knowing all of that, do you insist on pleading true to this allegation of a violation of probation?
Yes, sir.
I find you are pleading true voluntarily. You understand and appreciate the consequences of pleading true. An agreement's been reached where you would be pleading true, your probation would be revoked, you would be sentenced to 2 years in the state jail to run concurrently with other cases. Is that your understanding?
Yes, sir.
If I follow this agreement, you have no right of appeal of your case. Do you understand?
Yes, sir.
I'm going to show you what's marked here as States Exhibit 1. Could you sign that document voluntarily, understand it, discuss it with your attorney? Are the contents all true and correct?
Yes, sir.
States Exhibit 1 tendered into evidence and without objection admitted. Among other things, this states you are waiving all your rights of appeal if I follow this agreement, which I am going to do. States Exhibit 1 is part of the record. Pre-sentence report is registered. I'm going to follow this agreement and find that your plea of true to allegation 1 of the first amended portion of this first amended motion to revoke unadjudicated probation in this cause number, which was filed on February 25th last month. You have pleaded true voluntarily, knowingly, intelligently. That is enough to grant And this is to committing the offense of aggravated assault on or about December 2nd, 2023 in Harris County, Texas. That is enough to grant this motion to revoke probation by a preponderance of the evidence or greater. Thus, this motion is granted and your deferred or unadjudicated probation is hereby revoked in this case. Originally, in this case, you pleaded guilty voluntarily to the indicted offense of the state jail felony of burglary of a building. You were mentally competent to do so. You understood and appreciated the consequences of pleading guilty. There was sufficient evidence supporting your guilty plea. State's Exhibit 1 had admitted in that plea hearing originally in this case to find you guilty beyond a reasonable doubt. And I now find you guilty beyond a reasonable doubt based upon your revocation of probation. I am following this agreement. You were hereby sentenced to the state jail to a period of 2 years. You will be given credit for all time you have served in accordance with that, which looks like a substantial amount of time. Anything else? No, that is all. Thank you.
Almost lost it. You can finger from the See you later. Good. Right.
I have a good thing to add on. Is that your?
Yes, sir. That's
Where or?
do this play first.
Alan?
It's not get your more.
Sir. Look at your right thumbprint. Yep, is it black? Get up one more time. And it's a lot right there. Okay, we'll see this over.
Alan Moore?
Sir, I don't. I just want the six.
We now call 26 CR 159, the state of Texas versus Alan Moore. And you, Alan Christopher Moore,
Yes, sir.
correct? Here with Mr. Dusler, your attorney and the state's attorney. Does the defendant waive a formal reading of the indictment and the arraignment here? Can you proceed in summary?
Yes, sir.
In summary, sir, this indictment states that on or about January 12th of this year in Jefferson County, Texas, you committed the third-degree felony of stalking. And that is, listen, by sending electronic messages to another person. And it was done in a fashion that would cause a reasonable person to feel harassed, annoyed, alarmed, abused, tormented, embarrassed, or offended. Either of those or any collection of those verbs would result in a violation of law. Do you understand? Okay. You understand what you're charged with fully here?
Yes, sir.
And this is, if convicted, a third-degree felony, which means you face a term of not more than 10 years or less than 2 years in prison. In addition, a fine may be assessed not to exceed $10,000. Do you understand the punishment range that's applicable for any such case as this?
Yes, sir.
An agreement has been reached between your attorney and the state where you would be pleading guilty, not found guilty. So long as you follow terms and conditions of probation, you would be placed on deferred or unadjudicated probation, which would be up to 10 years in length, fined $500. You do well on probation, the term of probation gets shortened to 1/3, 3 1/3 years. Yes, sir. If I follow this agreement, you will have no right of appeal of your case. Do you understand?
Yes, sir.
How do you plead to this charge? So guilty or not guilty?
Guilty, Your Honor.
Are you pleading guilty voluntarily? That is on your own free will and because you are guilty.
Yes, sir.
I'll show you what's marked as State's Exhibit 1 here. Did you sign that document voluntarily? Understand it? Discuss it with your attorney? Or the contents all true and correct? State's Exhibit 1 tendered into evidence? Yes. Without objection admitted. Among other things, this states that you are mentally competent to enter your guilty plea. It's freely and voluntarily made. You know what you've been charged with. The indictment's been read to you. You've read it. You are guilty of the crime charged in any lesser included offenses. You are giving up your rights to a jury trial, rights to the appearance, confrontation, cross-examination of witnesses, and totally satisfied with the representation provided by your lawyer. All of this is true. It states, so help you God at the bottom. States Exhibit 1 is made a part of the record for all purposes. Is it pre-sentence report, Wayne? Yes, sir, it is. How long have you been in jail now?
Yes, sir, about, I want to say about 70 days possible.
How's that working out?
Because the Lord's blessed me with another day, so it's.
I wouldn't want to be in there.
Yeah, it's not easy, Your Honor.
There's a way to avoid that, you know. Fix it. Fix this mess. Move on. Have you ever been convicted of anything before in your life?
Well, I completed in 2018, 10 years in deferred adjudication for
in this county?
Yes, a long time ago, yes, sir.
In this court?
It was drug impact court, Judge Gist, and I completed it all in 2018. Since then, I have not been in trouble. No, sir.
Yeah.
Sure. Yeah.
New set of facts. I've got to tell you. I've been doing this for terms for over 40 years. Never seen such a poorly set of facts. What in the heck got into you? I mean, this is bizarre, right? Yeah. You think sending a picture of your penis to someone is going to woo them into affection with you and go out with you? Is that the way you deal with women? My God, you're supposed to.
I made a mistake, Ron.
All right, well, fix this. This is a clear mistake here. Think that is the way you woo a lady? No. Gotta show some respect to number one and to the ladies, and that's not it. Far from it. Shame on you for that. Anyway. You go on this one. This is just, don't ever do such a thing like this. All right, you've seen States Exhibit 1, and this states you're mentally competent.
Yes.
And I'm going to find these statements that you've signed here under oath of truth, that you are mentally competent to enter your guilty plea. It is freely and voluntarily made. You know what you've been charged with. You're guilty of the crime and any lesser included offenses. You were giving up your rights to a jury trial and the rights to the appearance, confrontation, cross-examination of witnesses, totally satisfied with the representation provided by your lawyer. All of this is true, so help you God. You have to speak out.
Yes, sir.
States Exhibit 1 is part of the record for all purposes. Presented before his way.
Yes, sir.
If nothing further, I'm going to follow this agreement and, but here's the only caveat because the warning. You've been on deferred before, haven't you?
Yes, sir, I have.
Yeah. Well, that didn't influence your future actions and decisions, knowing that we take crimes seriously, and you're looking at up to 10 years in prison in this one. Plus, again, no way to treat a lady. You're supposed to respect it. We're going to find you pleaded guilty voluntarily. You were mentally competent to do so. You understand and appreciate the consequences of pleading guilty. There's sufficient evidence supporting your guilty plea from States Exhibit 1 admitted to find you guilty beyond a reasonable doubt. But I'm going to follow this agreement and defer any finding of guilt. You will be placed on deferred or unadjudicated probation for 10 years. There will be terms and conditions of probation, which are normally customary. Number one, you will have no contact with the victim. Absolutely not. There will, you will, in any way, shape, or form, by the way, you will complete a moral reclamation therapy program, which is a good program. It helps people realize and appreciate the consequences of their actions. And it's a crime such as this one, where it's clear this is not only a crime, but if poor taste was a crime, you'd be guilty of that too. That's just disgusting. It's not dignified to another person, much less a lady. If you fail on this, your probation could be revoked. You could be then found guilty of stalking and sentenced up to 10 years in prison. How are you going to do?
I want to complete it. I want to complete it all, Your Honor.
Well, I guess you learned something here, huh? There's no way a gentleman should act. That is all. Thank you.
Hey. There's a real piece of switch to them. I didn't know the base that I can say this is huge. The last, they have on with Clifton, he does not seem to be running out.
Jonathan?
Yes, sir.
Two cases. It's 26 CR 44 and 26 CR 289. We're waiting on a doctor's
We have all
report.
4 H not.
Oh, it's come in?
Yes. We cannot make anybody come out. Just need them.
He's not competent?
He's not competent.
Or don't I need to make findings?
You do, but you don't need to bring him out to do that. So if you're confident,
Well,
you don't have
I mean,
to.
it's, well, let's see. If he's incompetent, I guess according to the doctor's report, we could bring him out. He wouldn't understand and appreciate what's happening anyway. And that would kind of.
Yes. Yes.
A waste of words. Two cases, again, involve Jonathan Chaikey Clifton. You know, I'm kind of.
So our females always and they act like you fucking so bad. No, it's fine. It's oh,
There it is. There's the crime. All right, the defendant in these two cases, 26 CR 44, is charged with the 3rd degree felony of tampering with electronic monitoring device. And it looks like he has multiple prior convictions in sequence. This is a 3rd degree felony, which would be prosecuted as an habitual felon status, I believe. Correct on that? And in 26 CR 289, failure to comply with sex offender registration. for life. In his case, it's a third-degree felony with, again, several prior convictions. So he's looking at no less than 25 years in prison, up to life imprisonment on each of these two cases. The court, in an abundance of caution and based upon suggestion that the defendant may be incompetent, ordered Dr. Ed Rapon, licensed psychiatrist, to evaluate the defendant for competency. He has returned an evaluation dated March 20th, 2026. The court will mark this as Court's Exhibit 1 on this date in these two cases and make them part of the record and sealed without objection.
Correct. No, that's fine.
And it's Exhibit 1 was made available in each case and sealed. In summary, Dr. Rapon determined that Mr. Clifton is not competent to proceed to a resolution of his legal issues. He is diagnosed with schizophrenia, chronic state of schizophrenia. And thus he is unable by law to proceed to trial till or unless he regains competency. What do we do next here?
You need to order for treatment. There's a lot.
And treatment will be ordered, and it may be helpful in this case since the diagnosis is of schizophrenia, chronic schizophrenia is deemed by Dr. Rapon to be borderline to mildly mentally disabled intellectual potential. So we may be able to pull in across the line for competency here. So he will be kept in custody, then forwarded to hospitalization or medical treatment for the hope that competency will be attained. Anything further?
The only other thing I just want to make the court aware of, we can't really deal with it today, is I do have a motion to withdraw pending against him, but since he's not competent now, we can't address that.
What was that for?
He's filed agreements with me in the state bar, which is pending now.
Okay. Oh. I think it's when he's incompetent. I mean, he can do this for every lawyer, and then he would never get a lawyer, never he'd be able to disrupt proceedings because he is incompetent. I'm certain that the rules provide that he is not fully aware of his decision making, and until we can get in treatment and we'll just keep it in a suspended state of for you to continue to be his attorney if he needs any kind of advice and until such time he becomes competent, and then we can find out what his feelings are about having you to continue to represent him. Thank you.
Thank you.
Don, did you have anybody else?
That's all.
Okay.
Yes, ma'am.
Reagan?
Yes, sir.
Reyes Castello.
He's a plea.
Reyes. Oh, he's got a lot of cases. That's 4. Ooh, look at all of them.